The rule of law and a transparent justice system lay the foundations for inclusive and fair development. In many African countries, there is a need for action to ensure compliance with the principles of the rule of law and justice. The project focuses on the promotion of the rule of law and judiciary and the improvement of the legal frameworks for entrepreneurs in Africa. In addition, the cooperation with bar associations and universities across Africa have built important cornerstones. The team in Ghana has worked on a long list of activities in the past years, from training of lawyers, establishing a network between bar associations, workshops to empower female entrepreneurs, and enhancing women's access to justice, to conducting research and studies, organizing summer schools, workshops for women judges in Africa, and analyses and baseline studies, and many more. An online conference was organized to exchange ideas between Germany and Ghanaian judges and court administrators on methods for implementing digitalization in the justice system, and to share the lessons learned in Germany and Ghana.
We don't usually get the opportunity to actually benefit from shared experiences of other jurisdictions so that we can inform what steps we are going to take. We don't want to reinvent the wheel. We want to take the benefit of what others have done and then customize it if necessary to our own situation, improve upon it for the use of our system.
In partnership with the Fair Justice Initiative, the project trained detainees of the Insawam female prison in creating face masks and hand sanitizers and distributed those to the local communities.
As part of our core missions, we provide skills training, educational training as well to inmates. So we tied this in with the COVID awareness program. And what we hope to achieve with this project really is to train these inmates for them to acquire some skills that they would rely on when they are out and when they are released. And this is supposed to give them some economic independence when they are out there to support themselves.
In cooperation with the Office of the Attorney General and Ministry of Justice, the project developed a web application to be a one-stop shop for case law in Ghana that provides a digitized collection of Ghana's previous and current legal decisions to encourage the complete transition into e-research, making it an indispensable part of the African legal profession. In Tunisia, Ghana, Cote d'Ivoire, and Mozambique, the team focused on supporting knowledge strengthening and exchange for lawyers and entrepreneurs, small business holders, founders, and startups through summer schools. Legal coaches from all over Africa
Good afternoon, ladies and gentlemen. My name is Dr. Kweku Innocent, and I'm a senior lecturer at the University of Ghana School of Law. Myself and my colleague, Rachel Hazel, will be the moderators for this afternoon's session. Let me welcome all of you formally to Day 4 of our International Conference on the Future of Legal Education in Ghana. This also happens to be the last day for our conference. And let me say that we have saved the very best for the last. We have an August panelist that you'll be hearing from very shortly, as well as some speakers. Now, before we get started, I'll introduce the chair for the occasion, and then he will take it over from there. So I'll say that the chair will be in charge, but the moderators will be in control. Before I introduce our chair, let me go ahead and give you a little bit about the house rules for this afternoon. Now, after the introduction of the chair, the speakers will go ahead and speak, and each speaker will speak for 15 minutes. We'll reserve all the questions after the speakers have spoken. So if you have any questions, please do well to note your questions down. Once we are done with the first session, then you can go ahead and ask your questions. After the two speakers have spoken, we will take a 5 to 10 minutes break, and then we will resume for the second and the final part of the conference. Now, the chair for this afternoon's session is Mr. Kweku Ansah-Asare. He's the Dean of Mountcrest University College. Mr. Ansah-Asare needs no introduction in the legal fraternity in Ghana, and I dare say even in Africa. He also happens to be the director of the Ghana School of Law when I was a student at the law school. So without much ado, I will hand over the microphone to Mr. Ansah-Asare to give his brief remarks and then invite our two speakers to the podium. Thank you very much.
Thank you, namesake. Her Excellency Professor Justice Icflea, my Lord, colleagues, let me first of all express my very sincere appreciation to the organizers for inviting me to chair this afternoon's event. As you may probably be aware, each time I make some passing remarks, they stir controversy. So I'm being careful this afternoon not to stir any more controversies, so that we can at least achieve a desired objective. But let me quickly read from the Saturday 8th November 1958 edition of The Graphic. And the screaming headline, Ghana Law School opens next month. In order to situate this afternoon's discussion in context, may I crave your indulgence to just read what, by kind courtesy of the editor and the director of archives of the Graphic Communications Group, we are able to feed you on this afternoon. And My Lord, with your permission, I read, quote, "The Ghana Law School is to open in Accra on December 29th, 1958, with 50 Ghanaian students. At a 60-minute press conference held in Accra yesterday, Professor J.H.A. Lang, Director of Legal Education, said this first course for would-be legal practitioners is being restricted to Ghanaians because of at least lack of accommodation. 1958. Very prominent restriction, lack of accommodation. Classes, according to Professor Lang, will be held in the Supreme Court on weekdays between 5 p.m. and 7 p.m. Professor Lang said persons wishing to enroll for the course must have a thorough knowledge of English, both written and spoken. They must have passed at least either West African School Certificate or the General Certificate of Education or some examination which the board considers is of equal standard. The Board of Legal Education, it said, might exempt certain people in exceptional cases from such conditions for admission into the school if it considered there were special circumstances justifying the granting of exemption. The fee for a whole year's course, he said, would be £50, payable in 3 installments of £18 on enrollment, £16 at the beginning of the second term, and £16 at the beginning of the third term in September, unquote. Daily Graphic, 8th November 1958. Today is 2nd December 2021. So 63 years on, we are back to square one, if not worse. If my maths will assist me, I believe it is about 63 years and 3 weeks. This afternoon, we've assembled to take stock. And then, in the light of the conference topic, the future of legal education in Ghana/Africa, the way forward in terms of the scarce or limited resources at our disposal. So we have 2 speakers, 4 panelists to walk us through the path towards expansion in legal education. The challenge I would like to throw to the speakers and the panelists will be to consider what exactly have been the restrictions that have inhibited our way, our progress, our forward march to the desired quality legal education, which was the dream and centerpiece of our first Prime Minister and President, Osajifo Dr. Kwame Nkrumah. What has gone wrong? 8th November 1958, the director identified a critical need, lack of accommodation. In discussing resources, I believe we are going to hammer this critical need. At this stage, may I kindly request everyone herein assembled to join me in thanking Professor Icflea here for making it possible for us to be in here. This building, at least I know how monies were raised. And it is a sore point that I underscore. Professor Icflea went cap in hand, approached lawyers to make contributions, to give their widow's mite. And when the late Professor Mills became vice president, he used his good offices to get cabinet to approve what Auntie Icflea needed to complete this project. We do not appreciate our people when, at least in times of need and crisis, they respond to whatever. How many of us know that Professor Icflea was the person who pioneered this project? How many times has the University of Ghana invited her to even come and speak as to how she managed to garner the resources to put up this enviable structure, this edifice that we are using today? I should like to think that and believe that the panelists are going to show or indicate the ways and means that we can raise much more money. We've met here to discuss resources. We want quality education. Quality education is labor intensive. Quality education is labor intensive. You need human capital. You need the personnel, the lecturers, the non-teaching staff. You need books. You need buildings. You need financial resources. How many lawyers has University of Ghana Law School produced since 1959 when it was established? This is not the first time that there is this assembly to consider. In 1962, Professor W.B. Harvey, the first dean of the Faculty of Law, then a department of the University of Ghana, placed a memo before the then council, just as we met this afternoon, to consider, discuss the way forward. In 1987, at a conference of Superior Court judges, which ushered in the birth of the Bench, Bar, and Faculty Conference, this same problem was discussed. So it is not the first time that the problem has been identified and is to be discussed. It's gone on before, it is still going on, and this debate is likely to go on forever unless we rethink and reshape the destiny of legal education of Mother Ghana. I am not going to address the needs of Africa. I'm not competent to do that. But I'm competent, like Trump will say, Ghana first. Ghana first. When we are able to solve our problem, then we can extend hand of friendship and assistance to our neighbors. But the fact that this school, University of Ghana Law School, was the first in sub-Saharan Africa, and today, 63 years on, we don't seem to know where to go. Like Amatedu's dilemma of a ghost. Shall we go to Cape Coast or Elmina? I don't know. Let us commit ourselves, rededicate ourselves, and say that we can do it. We have judges, we have professors, we have directors, we have lawyers, we have named them in high offices or higher offices. Go to the diaspora, they are there. Everywhere you meet, because this was the first law school. But do we do things to reflect our motto? To whom much is given, much is expected? Do we even know that we have a destiny in our motto? So, I'll end on this note that we pledge forthwith to do something before we die. Do something before you die. So let us do something. If every month, every past product of this school, the mother of all law faculties, will contribute 500 CDs, I don't think University of Ghana Law School will be an infant entity. Not at all. We don't want to give. We know the problems, militating against our forward man. So, without much ado, I will resume my insight, but at the appropriate time, I think I will hit the nail right on the head. But once again, please, let's applaud Icflea for their contribution. Thank you very much.
Thank you very much, Mr. Ansasari. As I indicated to you, we save the very best for the last. Now, let me acknowledge those of us that are joining online. Thank you very much for staying through with us from the beginning of this conference all the way to today. We acknowledge your presence this afternoon. If you do have any questions or comments, please don't forget to put them in the text boxes, and we will do well to acknowledge you at the right time and ask your question for you. Now, for those of us that are seated here, there's actually a conference Wi-Fi, which is a UGSOL conference 5G, and then there's UGSOL conference as well, and the password for both will be UGSOL at 21. So you can log in as well, and you can put some of your questions as well over there, and then we'll do well to ask them. Now, we'll go straight to our speakers for this afternoon, and the first speaker is going to be Mr. Kwesi Prempeh-Eck, who is the Director of Legal Education at the Ghana School of Law. And once again, he was my law of conveyancing teacher. So, Mr. Prempeh-Eck, thank you very much. You're welcome to the podium.
Thank you very much, Dr. Kweku Enison. Mr. Chair, Her Excellency, Professor Icflea here. Who taught me criminal law in 1983. Andreas this thing. It gives me much joy to be with you this afternoon. When I received the invitation, my response was that when my alma mater calls me, it is actually a writ of mandamus. There's no way you can refuse or turn down the invitation. And so I'm here to share a few thoughts on the resources we need in legal education. Sometimes when you hear people talk about the Ghana School of Law, there's so much controversy going on because more people are trying to gain admission than we can offer spaces to. When you have 15 faculties of law, whose graduates are all desirous of entering the Ghana School of Law, it is a big challenge. In 2013, when we realized that there was not enough space for the students who are applying, the issue of entrance examination was also introduced. And that is what we've worked with all these years. When we talk about the Ghana School of Law or legal education, we want to look at the legislature, okay, the directions they provided to us as a school. What are we supposed to do? What are we required to do? What are we supposed to follow in running the school? The Legal Profession Act, Act 32, gives us directions. And then you also have the legal profession, professional law course, post-call law course regulations of 2018. That is LI 2355 as amended by LI 2427. It gives us directions as to what we can teach, what can be taught, etc. Okay. When we look at the law school, I'm looking at the human resource first. And in looking at the human resource, we're looking at both the lecturers and then the non-teaching staff. At the law faculty, there are requirements before you are appointed as a lecturer. You must have an LLM, probably research in law, or a PhD. Even if you are appointed without a PhD, within, I think, 4 years or so, you must obtain your PhD. Otherwise, you are out of the door. And so that's the requirement. But when you come to the law school, the requirement is that you must be at least 10 years at the bar. You must demonstrate experience in a particular field before you can be appointed as a lecturer. For a tutorial master, you must have at least 7 years post-call experience before you can be considered as a tutorial master, not only because of what you know, but also your experience and your track record. So we look at all that. And then in identifying who should teach what, we look at part 1, for example, part 1, the professional law course part 1. We have the law, civil procedure, criminal procedure, law of evidence, ADR, and then commercial and company and commercial practice. Okay. So you must identify people who are knowledgeable enough and competent enough to be able to teach those subjects. These days I hear people say, oh, just engage more people to teach. It's not as easy as that. If the people are not competent, they cannot be allowed to teach. Sometimes I've had people who say, we want to teach, and you realize that they don't have any experience in that area of law. And although I'm desirous of appointing more lecturers, I also have to look at the fact that if this person is not competent, you cannot permit him to come and fill the space as a lecturer. Apart from that, before a person is appointed, we also have to look at the fact that how knowledgeable and competent is that person? Apart from that, is the person committed to legal education? Is the person desirous of imparting knowledge? Sometimes we've had lecturers that we've had to remove because they're not committed. They don't attend lectures. And what really puts me off is a lecturer who doesn't attend lectures and doesn't also inform the class prefect or management that today I won't be able to attend lectures. So you have 200 people driving to the lecture hall and you don't show up. No one knows what you are doing. No one knows where you are. It really upsets me. If you do that once or twice, then I have to look for an alternative. Okay. Apart from the requirements in part 1, we also look at part 2. Part 2, you have you have conveyancing and drafting. You have the law of interpretation. And then you have advocacy and legal ethics. And then family law and practice. All these subjects, you have to look for people who are knowledgeable and competent. And it's also a requirement that I have on myself, that the people who are going to be appointed are people who know their stuff. If they don't know their stuff, you can't appoint them. And sometimes I've had people who have tried to apply as lecturers, and they have mental health issues. How can you appoint that person? Yes, you need lecturers, but if the person has mental health issues, you cannot appoint the person. There'll be pandemonium in the classroom one of those days. So, and then we come to the next course, which is allowed by law to be taught at the law school. That is the post-call law course. That is for all Ghanaian students who have studied abroad in a common law jurisdiction. They are permitted to come and do the post-call law course. It used to be 3 months for a long time. And then in 2013, it was increased to 1 academic year, from October to June. And they are taught various subjects: civil procedure, criminal procedure, interpretation, etc. There's one subject that we added which is non-examinable. That is conveyancing and drafting. I told them that any lawyer in Accra who doesn't know land law and conveyancing will be embarrassed. If the great E.D. Combe was swerved 3 times in land that he wanted to buy, then if you are familiar with the practices abroad and you think that that is the same thing that pertains here, you'll be very embarrassed in front of your clients. So they are taught conveyancing by Justice Sir Dennis on a non-examinable basis. But I believe that they need that information to be able to survive as lawyers in Accra. You know that in Accra, the first Ghana word I learned was Ahon Shipon. That was, they are selling land. That was the first Ghana expression I learned. Okay. Apart from the teaching staff, we also need the non-teaching staff. And they are very important. They form a vital basis of the work we do. And we have to ensure that we have qualified and highly competent people who can help management to deliver on its mandates. And so we are very particular about who we appoint. In addition, we also got in touch with the University of Ghana Quality Assurance Unit to come and have discussions with our students so that they will give us feedback. And some of the feedback they gave us was very, very helpful in aligning our systems, in especially getting our registry staff to know how to deal with people. The customer care for a long time was not good, but I'm glad that due to this feedback, etc., we've been able to change the way we handle our clients, or our students, not only the students, but also the general public. Okay. The second thing I want to talk about is infrastructural resources. We are constrained at the Ghana School of Law. The student numbers have increased a lot. And I can trace it to the 2013 election petition. As people watched live on TV, the interest increased. Because initially, the number of people applying for admission to Ghana School of Law was just about 200, 250, more or less. But now it's increased. This year, 2,800 people applied to be admitted. We've only been able to admit 790 plus 499 who are incoming. We tried 2 years ago, the intake was 1,045 students. And so instead of increasing the cutoff point from above to maybe 60 or so, the General Legal Council directed that management should admit all of them. And so we introduced the triple track system. There were 3 different groups: Monday, Tuesday, Wednesday, Thursday, Friday, Saturday. It was very tough, but I applaud our lecturers and administrative staff. They all put their shoulders to the wheel and made sure we're able to complete the academic year successfully. Their private, for the lecturers who are part-timers, their private work suffered a lot, but they were committed to ensuring that the students did not falter. They taught them to the best of their ability. Okay. When we started the Kumasi faculty, we didn't have lecturers from Kumasi, so we had to fly lecturers from Accra. Every week, several lecturers were going to go and teach in Kumasi. And I wasn't very comfortable about that. For safety reasons, security reasons, etc. I wasn't comfortable with every week a lot of your lecturers are flying in and out. Okay. So what we did was we went to Kumasi and we recruited, based on recommendation, got lecturers in Kumasi who are now handling all the subjects. Now we have another campus at Gempa, and then now we've opened another campus at UPSA. All that involves a lot of attention. You cannot overlook anything because each student is important. You cannot give priority to Accra Main because that is where the head office is. Everyone is important. You have to make sure that you prepare them well in advance for the exams because they're all going to write the same examination. So if they are handicapped in any way, that is not a very good situation. So we are trying. Management is paying attention a lot to the needs of the students in all the 4 campuses. We have a law village project, which is ongoing. It is our plan that will give us a bigger space to be able to accommodate all our students. But then finances are not forthcoming. And so the project has delayed a bit. We are hoping and we are asking government to assist us to be able to finish so that we can accommodate all our students and all the people who are trying to gain admission to the Ghana School of Law. In addition to infrastructure, we are looking at the quality of the library facilities. If you are providing a campus, you should also have good library facilities. Because as for the law, it's in the reading. The other time I was talking to the UPSA students, and I said, you cannot rely on head notes to survive in a law school or law faculty. You must go beyond the head notes. Okay. So that is also one thing that we have to pay attention to. The other thing is the technological resources, PowerPoint presentations, and for example, during the lockdown, we had to resort to Zoom. Getting lecturers and students to accept Zoom as a form of communication was one challenge. Then there were financial constraints also. The other thing was internet instability. It wasn't always that we had internet. Okay. The 4th thing I would like to talk about is the financial resources. Most of the fees we get helps us in running the law school. But when it's not adequate, then what do you do? Okay. Because right now, when we receive money, 34% of every money goes back to government. And then we have to deal with everything else with the rest of the money that we have. There was a time when we had 128 students, I think 2 or 3 years ago. When we pay, electricity bill is 20,000 every 3 weeks. So you can imagine the pressure on management. But then, right now, the student population has gone up. So I think there's been an improvement in our finances. At the moment, the last thing I want to talk about is the fact that there's been a debate on whether the faculties of law should be given the professional law course to teach or not. That is an ongoing debate. Whether it should remain at the Ghana School of Law or it should come to the faculties, the important thing is that we should still continue to pay attention to standards. If it comes to the faculties, they would also have to be resourced well. And that is the important thing we should look at. That whatever it is, we should continue to look at the standards and pay attention to them. Thank you very much for your attention.
Please, another round of applause for Mr. Prempeh Ek. If you just joined us in person or online, this is the final day, the fourth day and final day of the International Conference on the Future of Legal Education in Ghana and Africa. And today we are talking on the topic of resources for legal education. We've already had our chairperson give his opening remarks where he mentioned the fact that the problem of resources started as far back as 1958. And then we had our first speaker, Mr. Prempeh Ek, talk about some of the challenges they are facing, some including human resources, where he says that they need people who are competent, who are committed to do the work. Our next speaker needs no introduction. For those of us here, we already know him, and we are pleased to have in our presence Dr. Peter Atupari, Dean, Faculty of Law, University of Cape Coast. Doc.
Mr. Chairman, colleagues, students, distinguished ladies and gentlemen, though I have been invited here, I believe, in my own right, permit me to extend to the organizers of this conference and participants of same warmest greetings from the Faculty of Law, University of Cape Coast. I am delighted to be given an opportunity on this platform to interact with and to engage colleagues in Ghana and on the continent, and to record my modest, if not candid views on such an important topic as resources for legal education in Ghana/Africa. As the Right Honorable Dr. Justice Benny Kamara of Sierra Leone echoed on the 30th day of November 2021, the integrity, quality, and depth of our appreciation of law and justice as a state and the governance structures of our republics on the continent are a comprehensive functionality of the kind of legal education we administer. It is also, or it is so because law provides the mechanics of states' existence, and it is the principal source of the fidelity of these institutions. So the interaction between right holders and duty bearers in republic, proper so-called, is a consequence of law. But today in Ghana and Africa at large, we say the legal education is at a crossroads. There is a need for a clear vision, articulated on a clear policy. Such a vision cannot reasonably emerge from government alone. It must come from the plurality of voices as a reflection of the multiple interactions of law subjects. In fact, necessary stakeholder consultation and input taking is apt. Legal education cannot be left in the hands of hegemons. As recorded earlier by other eminent speakers, the constitutional foundation of legal education in Ghana is embedded in both Chapter 5 and 6 of the 1992 Constitution. While Chapter 5 deals with fundamental human rights and freedoms, Chapter 6 captures the directive principles of state policy. At the continental level, while these directives remain hortatory in some African constitutions, including Nigeria, they are, after a long checkered judicial musical chairs,
from the 31st December case, the CIBA case, and finally in a unanimous voice in the National Lotteries case being declared justiciable in Ghana. There is therefore no question as to the quintessence of these principles in the construction of the overall fundamental architecture of human rights and, of course, justiciable rights in Ghana. Even in Nigeria, where such principles on the face of bare constitutional provisions are taken as not justiciable, the Supreme Court of Nigeria 19 years ago in the corruption action case declared them as justiciable if they are specifically legislated into law by Parliament. This might not be seen as subterfuges of constitutional principles or double constitutionalization of rights, but a twin light of hope, aspiration, and a demonstration of active legal hand in protecting rights in these countries. Mr. Chairman, the fundamental question on the kind of resources needed for legal education in Ghana and in Africa at large is traceable to three driving forces. One, the history and future of legal education. Two, the teaching philosophy, so far as legal education is concerned. And three, Mr. Chairman, regulation and governance. These three forces, in their joint relevance to the topic on the reference, are motivated by the following questions, Mr. Chairman. What are the fundamental legal values of our legal system? What is the expected lawyer for our republic in enforcing those fundamental legal values? Should legal education be taken on as a function of the objective needs of society? Should legal education be taken on as a reflection of group needs of society? Should legal education be taken on as a response to the wishes of discrete individuals, regardless of the general needs of the society in which these individuals are found? What sort of law do we want for our republic? What sort of role of law do we want for law and lawyers? What sort of education is required for this assigned role for law and lawyers? How might this sort of education be delivered for the achievement of this role and purpose? An honest answer to this set of questions, Mr. Chairman, I believe will determine what kind of resources are needed for legal education in Ghana and Africa. In our priority lists of things actuated by the reason of state and public reason, we should know where legal education is placed in this priority list. If it is last on the list, note that any suggestion in respect of resources without recourse to our positional value on the list of priority is a dead one. So the determination of the fundamental question on resources must be preceded with a holistic engagement of the stakeholders on the position of legal education on the state priority list. In addition, if this question is ceded exclusively to politicians, then the answer might lack the balance of interest in the consideration. Above all, if the question is reduced to the control cycles of law teachers, then the interests of consumers of legal education, in this case students and industry, might be shelved, thereby reducing the objectivity role of the answer. With this background, Mr. Chairman, permit me to take you through a roll of things that I think we should consider. And these things have been mentioned by my colleague speaker, so I'm going to ask questions as I mentioned them, just to provoke discussion. One, we're talking about classrooms, libraries, tutorial systems, legal clinics, moot court rooms, lighting systems, books, internet, furniture, food, accommodation, water, offices, learning commons, etc. That's number one. These are the things that somebody will be talking about. Number two, human resources. And in this case, I am glad that the first speaker mentioned staff, in this case, teaching staff and non-teaching staff. But there are three key things we have to consider. The quality of training, adequate numbers, and then accessibility. Quality of training, adequate numbers, and accessibility. And there's a philosophical justification for these three key things. Admission of students produces a contract between the student and the university. There's a promise to give a particular value to the students. The students have promised to pay and have paid for that value. Therefore, the delivery and the process must be consistent with this contract. To what extent are the expectations of students met? Questions for us. What do you teach? And how do you teach? Do you spend time talking about your personal experiences? How relevant is that? Do you teach things that you are comfortable with? Or teach things that are entailed in the contract for which you are engaged? Do we take decisions by reference to students' reviews when students review us as lecturers? Does the lecturer understand the classroom psychology and the sociology of the class being taught? Are courses assigned on the basis of expertise or mere personal preferences? Who will teach constitutional law and then will put up hands? Is it because you personally prefer to teach, or you have expertise in constitutional law for which you've been assigned constitutional law? Are faculty recruiting for specific reference to needs or just adding numbers? Are we adding numbers, or we are recruiting because we need the people? Are lecturers teaching in accordance with the strict terms of course outlines? What are the effects of lecturers' evaluations? When you're told that you can't teach, you are boring, your teaching methodology is bad, we don't understand, and these are parts of suggestions from students, what do you do? Are findings or feedbacks on students' evaluations determinant of you being at post? Note that the human resource question is also entailed the judiciary. One of the sources of law engaged by the students and consumed by the people of a state is judge-made law. Is the quality of the bench apt? Are judgments well written, reasoned through, conclusions reached, and supported by thorough analysis? Are we able to communicate frankly to judges on the quality of their work? Yesterday they said we should speak the truth. So permit me to speak the truth. Are we able to communicate frankly in this case? To what extent is the quality of law graduates a function of the quality of law teachers and the bench? Are these two well resourced for their work? Number 3, salary and conditions. How are lecturers paid? What conditions exist? Why should a person who is 1 year at the bar be paid 9,000 plus when engaged at the AG department, and then a lecturer with a PhD and 20 years at the bar be paid less than 9,000 as a lecturer? The rebuttable that such is the choice of the lecturer is reactionary. Who should teach and produce personnel for the AG? Number 4, legislation. Sufficiency of the science of legislation. Mr. Chairman, the authority of law on legal education is only defensible if it reflects the collective aspiration of the state. It must be guided by history that cannot be prosecuted with a mindset locked up in dated propositions and abandoned context. In other words, the law on legal education cannot be reasonably anchored on a context and attitude held by our ancestors. Put differently, the law on legal education and his philosophy must not be left behind the present and compelling collective aspirations of our society. Do we have surveys on this? Or we are just talking and being inspired by contextless words, ideas, and phrases? What is the social data deployed and relied upon by the legislator on legal education? What is the data from industry on our current century that feed on a memorandum for a bill of legal education? What's the data? And this is important because if you look at the legal history, it was mentioned here that a number of legislation were considered. The Supreme Court Ordinance 1853, Supreme Court Ordinance 1876, the Legal Practitioners Ordinance Cap 8, that's 1931. You have Act 32, Legal Practitioners Act, Act 22, 1958, the Legal Profession Act, Act 32, 1960. All of this, there's no attempt whatsoever that social data at any point in time that they were legislated, the social data was current and was considered by the legislator in this regard. So it was just, we move on, we just amend, and then we incorporate these provisions. How relevant is that? Number 6, funding. Does the state adequately invest in legal education? What was the population of Ghana in 1958 when the School of Law was set up? Have we looked at the present population and attempted any equalization of the space at the law school? Why should government and stakeholders in legal education think that it is reasonably justified to broaden the space at the faculty level and to shrink the corresponding space at the law school? 7, subjects collaboration. Is the conversation on legal education one of monologue, or is one of pluralism? That is, with all necessary stakeholders on board. Is legal education one of a public good, as provided for in the Constitution, and how are public goods distributed in this country? Number 8, governance and regulation. And I provide some philosophical justifications for that. Law is an instrument of critical thinking. Law is the vehicle of justice. Law is an embodiment of rights and duties. Law is an aggregation of society's moral principles. Law is a reflection of public interest and public reason. Law is the basis for limited authority and distinguishes naked power from legal authority of the state and, for that matter, government of the republic. The appropriate laws or pieces of legislation are ineluctably part of the bouquet of the resources needed for a successful legal education in a state. You can't do that without appropriate legislation. Questions for you. Is the management of legal education in the hands of hegemons? Or there is statutorily imposed relevance of a section of the subjects of legal education on us? How close or open is management of legal education? Is there some appreciable level of transparency in the management? We have to, how have we strengthened our ethical standards in the delivery of legal education? How have we strengthened that? And that should form part of the tray of legislation that we should be dealing with. And ethical standards, I think we should consider the following. How have we dealt with protocol admissions? Protocol admissions. Are we able to deal with that? Is the issue of sex for grade real, and are there any findings from a credible research or surveys, and what happened? This just been raised, and nobody is talking about them. To what extent are lecturers able to annihilate ethnic and political origins from their dealings with students? And these are issues that are captured from students' evaluations of us, and we think that is not necessary. Have we considered the dilemma associated with the entrance exams, where exam questions are set by a group, marking schemes by another, and then the marking itself is done by another group? These people do not know each other. Do parents call lecturers to complain about poor grades of their wards? And I'm sure when Mr. Kekul and Sansari was at the law school, nobody has done that. But we might have some experience in the recent past. To conclude, the question about resources of legal education in Ghana is about the necessary environment for the said legal education. This environment is an entailment of multiple things that must healthily interact. I dare say that there is an element of indivisibility or interrelatedness of these things. But I must say that we are at the crossroads with legal education in Ghana due to the absence of a legal academy, resulting in less improvement in teaching and research standards. This has pulverized an honest and comprehensive national discourse on law, rights, justice, and above all, legal education. Let's face the questions and let us be honest with our answers and we'll get the solutions. Thank you.
Thank you very much, Dr. Atupari. And I think a round of applause for all our chairman and our two speakers who have already spoken. We thank them for their thought-provoking insight. I dare say that all that we have done this week, in this international conference is meaningless unless it is tied to adequate resources for legal education. And that is what makes this afternoon's panel very, very important. I think at this point we will break and take questions from the audience who are seated here, as well as those that are joined us online. So if you do have a question for any of our august panelists, you are seated here, please raise your hand and we'll give you the opportunity to ask a question. If you are online, as I indicated, go ahead and put your question in the text box and we'll do well to ask your question as well. So we have about 45 minutes to do the Q&A, and then we'll take a short break and then resume. Yes? Do we have one mic in the audience that we can pass it around? All right.
Thank you very much, Mr. Moderator. Thankfully, the last speaker touched on almost all the points that we need to take into consideration in the impartation and acquisition of legal education in our beloved continent. One point he mentioned, which I think I really feel passionate about, is that which revolves around limited state intervention in education. And of course, he referenced me when he started the paper, and I saw how he tied that reference to this point, which I really want us to look at very seriously. The problem is this. People say the state is overburdened. The state is overstretched. The wage bill is high. But when you critically deconstruct the content of state's budget, you see that the state expends financial resources on sectors that are not as important in comparative terms to the legal sector. The legal sector is broad. So broad that if we adopt the stakeholders approach, we will see that it is constitutive of a network of very important persons making meaningful contributions to the socio-economic and political development of our continent. Our continent, we know, is trapped in the midst of abject poverty and a plethora of other problems that we have the capacity and resources and infrastructure to address. But because we are not prioritizing our activities and spendings, that is why we are where we are today. So let us please take a position at the end of this conference and sell this idea to member states of our beloved continent that contemporary governance is all about democratization and the rule of law and human rights. And these are fundamental legal ideals. They are constitutive of the structural and even behavioral architectures of our continent. If those who are to give credence to these ideals are not motivated in the context of particularly public sector management through policy formulation, implementation, and evaluation in respect of those points he raised, I'm afraid. I thank you.
Thank you very much for your comments. Any questions? Yes.
Thank you very much. I would want to revisit this issue because it has run through almost all the days here, but more directly to my former director and my classmate, Prempe Egg. I have been with him for 7 good years at the Ghana School of Law under the directorship of the chairman. And I think something fundamentally would have gone wrong Because the way the law school training program was structured over the period I was there, I didn't find the need to start having invisible examiners who have no responsibility and do not account for the type of decisions that they take. And if you have those who set the questions, those who mark, those who prepared, there must be something fundamentally wrong to have led to this new development. I also did remember how questions for every subject were moderated. Quite often, superior court judges with expertise in the area were asked to take a second look at the questions and the marking scheme, just to be sure that the level of proficiency expected of the students are captured in the question. I've had the opportunity of reading a number of the questions subsequently. And it is basically like you just ask questions. And if you ask the person asking the questions, what do you intend to achieve? Or what do you expect to get out of the student in this question? It becomes very, very difficult. And I believe very consciously that if isolated cases had occasioned a shift away from that system, I think that's not the best way to go. When these isolated cases come, you deal with them head on, correct them, improve the system, and continue. And not to abandon it and experiment with something that cannot even be scientifically substantiated. In pedagogy, there is no way that a person who has not taught a student or has not taught that subject consistently will be competent to examine a student. Because the grading curve is done in such a way that you use the teacher-student relationship to try and address otherwise bad situations. And Prempe will remember we had 3 critical cases. Today, they are some of the best practitioners I've come across in the country. But if we did not apply that grading curve properly, they would have been out of the law school and they couldn't have passed, just because they had latent problems that were not discovered until it was time for exams. I think the General Legal Counsel needs to look hard. I've looked for almost all the information to find out what justified a movement away from the old system. And you come across the usual things, that they say exams questions leak. Who is telling you they don't leak now? That they say there's favoritism. Who is telling you there's no favoritism, if not multiplied twice now? But at that level, there was a responsibility of people to account. If a lecturer conducted or misconducted himself in an unethical way, the procedures for bringing that lecturer to book were there. But lastly, on the human resources, we have ample evidence. I know how Mr. Ansar Asare literally went around doing head hunting to get teachers for the law school. I remember he harassed me at every place I went and insisted that he thought I should come and teach at the law school. Eventually, I didn't regret it. Of course, I had to leave based on governmental demands and things like that. But I think the head hunt can bring out the people who are competent to teach and operationalize your definition of competence in a very, very objective manner. Because we will always be found wanting if we do not get the criteria of what competence is. Is it competence based on the certificate? Is it a track record of public knowledge or academic knowledge in that area? Is it one about an individual or a group of a panel assessment of the person's competence? You need to do an objective assessment in the recruiting process like it's done at the level of the faculty, where it is a very strict peer review to admit their colleagues inside. Thank you.
very much. Any other questions? Yes.
Thank you, Kweku. There is a comment I'd like to make on what Dean Atopare raised as to the conditions of service. I remember when I was about 10 years old, people will often remind my father, who was a teacher, that his reward was in heaven. And it is with some regret that I make this comment. Members of the legal class are taught by law lecturers. They retire on their full salaries. They are treated more or less as Article 71 officers. Judges who are taught by law lecturers retire on their salaries. A certain category of public officers who retire on their salaries. Law teachers are excluded. We have raised this time and time again, year on. My plea to this conference is that for once, the whole nation, perhaps the continent of Africa, will recognize the enormous and significant contribution of teachers of law, so that African governments will do the needful, do something about the conditions of service of law teachers. Oftentimes, our own members of the bar associations, the judges, they stand guard over better conditions of service for law lecturers. Why is it that law lecturers are not agitating for improvement in their conditions of service? Civil servants do it, public servants, but the law teacher is always saying that, oh, I have a moral obligation towards the student, and therefore I'm unable to lay down, my tools, and therefore we die poorer and suffer in disdain and in abject poverty. And it's something that I think for once this conference should consider. Pass a communique addressed to various continental governments about the plight of the law teacher. When Peter raised it, I thought it should have been a critical component of this conference, and not as a passing remark or a small topic in somebody's address. It's a very, very critical thing that you should consider. Then Benkumbo, it has led to corruption in the examination system at the Ghana School of Law. The very foundation, the integrity of the examination system is gone. When I saw the advert in the graphic that they were going to establish an independent exams committee, I approached the Chief Justice and I protested, because it was new to me. It had never happened. And those who taught at the law school when I was deputy director and director, who bear testimony. You dare not, a lecturer, you dare not. I'll collect your questions 1 month before the exams and sit you down. We'll moderate it and get external examiners. The Chief Justice was not involved, the Attorney General was not involved, the Bar President was not involved. And if you had an interest, you failed to disclose. If it was detected, I'll apply the rod. And thereby, I became the target of people who did not like the right thing to be done. I don't think my good friend Kwesi has been responsible for what is going on. It is interference from the corridors of power. So you need the solidarity and cooperation of everyone here, teacher and student alike. But we are all in this mess. We are our activities and what we say and what we do. It is our students who bribe the teachers to do the wrong thing. The teachers, those who are setting the questions, they are selling questions, have been on air protesting. Students go and pay. And then they turn around that they've been failed. If you do the wrong thing, how do you expect the right thing? Then you want quality legal education. When from the inception, you are involved in bribery and corruption, nepotism, favoritism. If we don't stop these things, this conference, whatever we do, will come to naught. We need an attitudinal change for the better. The dean raised the issue of moral obligation, qualification to become a lecturer, the director himself. If you look at Article 128, Clause 4 of the Constitution, there are 2 key qualifications. The person must be of high moral character and proven integrity. What has happened? Where did we go wrong? Why have we sacrificed the 2 key conditions? Ladies and gentlemen, these are food for thought. Thank you.
Thank you very much. I think the takeaway is that it's a collective effort of all of us if you want to get this to work. But obviously, when it comes to the issue of the conditions of service of lecturers, I think Dr. Kumbo nailed it right on the head, and then Dr. Topari as well. Of course, there will have to be positive incentives before you can go ahead and be able to recruit the very best. And I think that some of us have noticed that in recent times, some of our very good products are leaving the classroom and they are going elsewhere. We need the good people to stay in the classroom as well. So we need to make sure that the incentives are well aligned to keep people or good teachers in the classroom. Dr. Tupari made a comment and indicated that when we are here, as teachers, that there's a contract, there's a contractual relationship that we bear to the university or to the institution that employs us. And as a result of that, we must ensure that we meet our contractual obligations. In fact, I had an interesting experience where one of the students had indicated, this student was not coming to class, had indicated that, well, we have a contract as well with the university. We have paid our school fees and we are in class. Your job is to teach us, and I did indicate that, well, to be able to do my job, you have to come and sit in the classroom before I can discharge my contractual obligations as well. All right. With that, there are a few questions online, and I'll let Ms. Hazel go ahead and read that.
Thank you to all those joining us online. And this question goes to Mr. Premper Ek from One Echo. I think the first question is more of a statement which requires you to comment on that, say, than a question. So, from Echo, he says, please, a question for Mr. Premper Ek. You mentioned suitability of lecturers and said you will not hire lecturers with mental health issues. Sir, please note that mental health is treatable, and inclusion dictates that people with mental health issues are not excluded from the work environment. So that is the first question from him. The second one says, in addition, will people with histories of sexual abuse allegations as well as other criminal offenses be prevented from teaching at the Ghana School of Law?
Well, when it comes to the example I gave of someone with mental health issues, I was not going to experiment with the students. If his situation is sorted out, then we can employ him. But when I know that he has mental health issues, I can't engage him and then be treating him whilst he's supposed to be teaching. That's my position. Okay. The second thing about sexual harassment, if I know the character of the person, before I engage you, I will not engage you. It's very simple. There have been times when people have been told that this person is very good professionally and everything. But then I will not. If I know that those are some of your attributes, I will not appoint you. It's very simple. Okay. As Mr. Ansasari said, we look at moral integrity, and then we also look at how you conduct yourself, etc. There was one instance where we wanted to take a decision about someone, and I was told that, oh, it doesn't matter. He knows how to teach, so just take him. And I said, no, I can't do that. Okay.
Thank you very much, sir. And I hope that answers your question, Mr. Eko. According to Mr. Prempe Ek, treat your mental health conditions and then we'll entrust the students to you. And as stated in the statute, if you're not a person of high moral character and proven integrity, you will not be allowed to teach students at the Ghana School of Law. I think it's appropriate for us to take some time off, break to cool off, to enjoy our snacks and to stretch our legs. So we'll take a few minutes to do that. And after that, we'll continue with today's discussion. Thank you.
On the promotion of the rule of law and judiciary, and the improvement of the legal frameworks for entrepreneurs in Africa. In addition, the cooperation with bar associations and universities across Africa have built important cornerstones. The team in Ghana has worked on a long list of activities in the past years, from training of lawyers, establishing a network between bar associations, workshops to empower female entrepreneurs, and enhancing women's access to justice, to conducting research and studies, organizing summer schools, workshops for women judges in Africa, and analyses and baseline studies, and many more. An online conference was organized to exchange ideas between Germany and Ghanaian judges and court administrators on methods for implementing digitalization in the justice system, and to share the lessons learned in Germany and Ghana.
We don't usually get the opportunity to actually benefit from shared experiences of other jurisdictions so that we can inform what steps we are going to take. We don't want to reinvent the wheel. We want to take the benefit of what others have done and then customize it if necessary to our own situation, improve upon it for the use of our system.
In partnership with the Fair Justice Initiative, the project trained detainees of the Insawam female prison in creating face masks and hand sanitizers and distributed those to the local communities.
As part of our core missions, we provide skills training, educational training as well to inmates. So we tied this in with the COVID awareness program. And what we hope to achieve with this project really is to train these inmates for them to acquire some skills that they would rely on when they are out and when they are released. This is supposed to give them some economic independence when they are out there to support themselves.
In cooperation with the Office of the Attorney General and Ministry of Justice, the project developed a web application to be a one-stop shop for case law in Ghana that provides a digitized collection of Ghana's previous and current legal decisions to encourage the complete transition into e-research, making it an indispensable part of the African legal profession. In Tunisia, Ghana, Cote d'Ivoire, and Mozambique, the team focused on supporting knowledge strengthening and exchange for lawyers and entrepreneurs, small business holders, founders, and startups through summer schools. Legal coaches from all over Africa support students with their participation at international legal competitions.
The pleading is over. I felt confident. They didn't ask many questions, but I was able to finish all my arguments.
The project also produced a podcast that shared general knowledge on legal background information.
Most African advocates will be guided and be motivated so that they will go all out to give their all for the vulnerable, the poor in society, and bring justice to every manner of person who may need this justice, and without them, they will languish in jail.
Several workshops and activities that strengthen women lawyers have taken place in Cote d'Ivoire. The team also supported the availability of legal aid in communities on access to resources, land conflicts, and women rights. With a specially designed truck, the team, with the support of the Ivorian legal practitioners, have visited communities giving free legal advice on request.
L'association des femmes juristes a pour mission de divulguer, d'informer et de sensibiliser les populations sur les questions d'ordre juridique et judiciaire. Et dans ce cadre-là, elles ont créé les cliniques juridiques, qui sont des centres d'écoute, d'orientation près des populations. Donc, elles sont proches des populations, elles orientent les populations à aller dans ces centres. Et dans ce cadre-là, ça oblige aussi les gens à parler. Parce que ces problèmes de violence basée sur le genre, de viol,
so if you can tell your colleagues that are in the foyer to come in so we can get started. Those of our colleagues that are in the foyer, if you can come in so we can get started.
Surtout le viol. Avant, quand on partait au champ comme ça, là, on a peur. Mais depuis cette activité est venue, là, on ne nous agresse plus.
Ici à Zokogwe, nous avions beaucoup changé. Dans le passé, les gens frappaient leurs femmes. Mais depuis que le cabinet juridique à Zokogwe, nous connaissons tous la loi. Tout le monde marche sous la loi. Et ça nous a appris beaucoup de choses. Travailler avec nos enfants, avec nos femmes surtout. Aujourd'hui, on peut même aider une femme à son absence, on peut aider une femme à préparer. Nous respectons la loi.
With these and other activities, the project has helped to establish partnerships in various African countries, which lay the foundation for fair and inclusive development. The team will continue their work through cooperation, capacity building, national and transnational dialogue, and assist partners in Africa on their way to promote the rule of law and judiciary. The rule of law and a transparent justice system lay the foundations for inclusive and fair development. The project focuses on the promotion of the rule of law and judiciary in Africa, with access to justice initiatives and the improvement of the legal framework for entrepreneurs. Some of the activities include summer schools with universities across Africa and supporting students with their participation at international legal competitions. Establishing networks and trainings with African bar associations, improving e-justice and digitalization in the justice
Hello,
sector,
everyone.
and developing a web application for case
Welcome
law in
back
Ghana
to the
that
second
provides a
session
collection
of
Ghana's
our
legal decisions.
plenary session,
Training
and we are
detainees
still
of Ghanaian
talking on
prisons in creating face masks and
the
hand sanitizer.
we are still talking on resources for legal education. For those of you who just joined us, we had the first session and our speakers and the chairpersons have already given their remarks. As Mr. Kweku Ansasari said earlier, we used to think teachers' rewards are in heaven, and I agreed with that until I became a teacher.
I didn't know I was the first panelist. For legal education. I think it was Dr. Tupari who asked the question, what is the purpose of the legal education? What are the social requirements that necessitate legal education? Because until you know, you will not really know what kind of infrastructure you want. And over the years, I've realized that when it comes to education, everybody expects government to provide whatever, to provide everything for the legal education or for the kind of education to go on. But buildings, classrooms, and equipment are crucial to quality legal education from my point of view. High quality infrastructure facilitates better instructions and improves the student outcomes as well as the level of satisfaction of those providing the instruction. I say this because when I first came to this university many years ago, the law faculty was at the gate. when I first came to teach in this university, coming from Oxford University, the law faculty was a series of barracks buildings. To be precise, 3 barrack buildings with a library at the bottom of it. Literally, barrack buildings. I think whoever designed it just sat down, drew 3 lines. Offices, classrooms, administration block, and library. I was appalled. And it didn't give the environment is not anything to write home about. The buildings were old. They were 40 years. Apparently, they were supposed to be temporary. But at the time I came in, they were 40 years old. Still temporary buildings. Anyway, that's history now. If you want high quality lawyers, and I'll stick to legal education, I will not talk about other forms of education. You want to produce high quality lawyers, you must have an environment that is conducive to good teaching, good learning, good experiences. I don't know why I was asked to talk about infrastructure, but infrastructure does not come cheap. What I've told you was from the inception of the law faculty for the 40-something years. When I came, it was over 40 years old. Nobody could even tell me exactly how many years. And so for any institution to begin to think about quality education, that institution must begin to strategize. What kind of building do we want? How many students are we going to cater for? And how are we going to keep the building in the pristine condition that we'll find it when we first move in? No government is going to give you money to build the kind of law school or law faculty that you want. Because I think the point has been made. In terms of priority, legal education doesn't come that high on government funding agenda. But one thing I've found out by experience in this country, and in recent times I've been frustrated, everybody expects government to do everything. Even in a village where a rainstorm has destroyed classroom buildings, where a little call for communal labor buildings. You see people on television, we are asking government to come and repair this. We are asking government to come and repair this. We don't seem to have any edge at all to want to help in our communities through communal labor, through a little bit of contribution here and there. Using the University of Ghana Law Faculty as an example, when I was a lecturer, senior lecturer, blah, blah, I kept harassing my deans. This building is not fit for purpose. The Faculty of Law cannot be this place. It's a disgrace. Because we had a lot of arrangements with universities abroad, American universities, our neighbors, Nigeria, and so on. And we're in those buildings, which were cracked, and we're always afraid that if something drastic happened, like an earthquake, the buildings will come tumbling down, hopefully without us being in them. So when I became dean, I don't even remember what year, I think 1995 or something. I said to myself, having harassed every other dean in this school, 97, I think it was 97. Having harassed body, why don't you begin to walk the walk, the talk? So I called a meeting of my faculty. I told them that we've been complaining about these buildings for years. I love challenges. I don't have anywhere, but I want to build a new fit-for-purpose law school. Nobody opposed me. I wanted the faculty as a whole to own the idea so that implementation doesn't become one person problem. Everybody agreed. And we started. First of all, we needed a plot of land. That was easy. The Vice Chancellor said, the whole place is there. Pick whatever you want. So we picked this place. To build, you need architectural drawings. And architectural drawings cost 4% of the total cost of the building. And when this building was originally done, the cost was $1 million. So we would be paying 4% of $1 million as architectural fees. I thought about it. I had a daughter who was married to a first-class architect who was trained in Brazil. So I called him and I said, my dear boy, I want you to design a law school for us, but for free. Well, not exactly for free. Your name will be on the building as having donated the drawings to the faculty. And that is worth more money than the 4% would have paid. He agreed. He said, I'll do it. You have to give me your brief, but you have to pay my engineers who will do the structural drawing. I said, no problem. That wasn't very much money. The rest is history. There was I didn't have one penny anywhere. So good infrastructural resources require fundraising strategies. The law school has set up an endowment fund. It's in the right direction. But to do something like this is very expensive. And one may not be able to use the endowment fund to do it. So you have to strategize. How are you going to raise money? I think it was Mr. Ansari who said that if every product of this faculty who has left pays 500 Ghana cedis, it will go a long way to do something. Well, I figured that we had enough lawyers in the system. So we began by doing a database of all the lawyers in Ghana, not just Accra. And I wrote personal letters to them. I made personal calls. And I said, we are doing this. This is the cost. We want you to contribute because at the end of the day, we are going to have on this building a list of every lawyer who contributed to the construction of the building. Do you want your grandchildren one day to come and stand there looking for your name and not finding it? You will be dead and gone, but they will not be very pleased with you. We are also selling reading rooms, lecture halls, you name it. You have seen, those of you who have been to the faculty, you've seen some. The Icflea reading room, the Moses Baden lecture hall, so on. It was not easy because we are not used to, unlike the Americans who contribute to their alma mater. We are not used to that. So it was a new concept. But people were happy to try. So we instituted an alumni homecoming in March every year. We solicited alumni homecoming, only kinky and hot pepper and fried fish. That's all we served. But we got drinks from the drinks companies for free, and we sold them at cutthroat prices. I remember one lawyer asking for a bottle of mini club beer, and the girls told him the price. He said, "What? Are you people crazy? How did you fix such a price?" They said that I was standing on the corner. He said that she did it. He turned around, looked at me, paid for the drink, and walked away. It was a fundraising activity. Through that, we began to raise the funds for this building. I had been to many law schools in America, in England, in Africa. So I gave a brief which I thought could stand the light of day. And this is the brief, what you see. Unfortunately, towards the end, there was a bit of truncation of the design, so we've missed a part of it, but it's probably understandable because it had got to a stage where the building had to be finished. Otherwise, it would acquire the reputation of the chemistry building in this university, which took about 30-something years to build from beginning to end. The late Professor Mills was always anxious that we put up this building. So when I started, he was vice president. I called him one day. I said, "Fifi, can you come for lunch?" Our lunch at the law faculty was roasted plantain and groundnuts. So he came to my office. We all had the roasted plantain. I said, "We are starting the building." I showed him. But what I need from you is money for the foundation because we cannot do that in piecemeal. He said, "Okay, I'll try." Within a week, he called me and said, "Go to the finance minister and collect your check for the..." It had been costed, so he knew exactly how much. The finance minister saw me one day and decided he didn't want to know. He was a very good friend of mine from the university anyway. He saw me and said, "What is it?" I said, "I hear you have my check. Can I have it?" He said, "You go, we'll bring the check to your office. Please don't come here again. Because people will think I've done something wrong." That's a bad reputation I had. Anyway, the rest is history. This building is here. We're all very proud of it. Now, when our colleagues come from America, from the UK, from Asia, wherever they come, we are very proud to receive them. Strategy, fundraising. In American law schools, one of the qualifications of a dean, or for becoming a dean, is the ability to raise funds because you need a lot of money to keep your infrastructure. You need a lot of money to keep this place as pristine as you see it now. We have to keep it like this. That means maintenance, repairs, promptly done, not leaving anything to rot for a number of years before tackling it. Bulbs go, they are changed. I can see a number of them are not on, but I don't know whether they are dead or... technological the equipment. A building like this must have Wi-Fi. And it does have. Because when I started coming here, I realized that the foyer was full of students with their laptops. So I asked, what's going on? They said, oh, they come to use the Wi-Fi. They are not necessarily law students, but they come to use the Wi-Fi, which is a very good idea. In my time, I didn't have to have a laptop to be at the law school. Today, you have to have a laptop. You have to be able to access. The library resources is very important. You need to be able to subscribe to all the number of productions outside the country. And students need to be able to access those resources electronically. I don't know whether every student in this school has a laptop. But even if they don't, the school must have a computer library where they will be able to go and do their work and print their work. I cannot see any lecturer accepting handwritten essays, where sometimes you can't even decipher the handwriting of the students. So, raising funds is important. There are many ways in which you can raise funds. A law school like this must have a fundraising committee, a permanent fundraising committee. People are happy to mobilize themselves, you know. People are happy to have, but this auditorium has not been named after anybody. Is there any lawyer here who is willing to pay for it? We can cost it. You pay for it. It becomes so-and-so auditorium. We have more lecture rooms that have not been bought. You are ready. You are welcome to pay for them. Maybe Abochi will buy one of the classrooms. And Sassari, I know you contributed a lot, because even the old place, which was not fit for purpose, you paid for the renovation of the dean's office. You did a lot, but you can still buy a classroom. So I think I have touched on most of the things. Good quality infrastructure does not come cheap, but there's no point on this school looking to government to put up this building. We have the management of this school has to be innovative to be able to keep all its resources in good order, especially the infrastructure. The lift, after I wasn't here, I was out of the country for 12 years. I believe when the building was finished, Professor Mills came here and said, where is the lift? It was one of the things that had been removed because of the need to finish. And he ordered for the lift to be put in so I think he organized for the payment of it. But a lift in Ghana needs to be maintained regularly. Otherwise, you come and find it not working. So fundraising is very important. And the object of fundraising would have to be, first and foremost, the past product of the school. I remember one day when this building was going on, the contractor gave me a bill of 1 billion something. I had never seen 1 billion written like that. So when the bill was given to me, I called my colleague. What was that? How much is this? He said, Dean, it's 1 billion. I said, where are we going to get that money from? Because we had money. We were raising money. We were raising funds, both dollars out of my own pocket, I would go to America, organize the alumni, and raise funds. I'll go to the UK and do the same. But we didn't have 1 billion in the account. But desperate situations require desperate measures. So we took some desperate measures. And within the 4 weeks, we were able to present the contractor with the 1 billion. Because it got to a point where they would come to my office and sit at the secretary. Then the secretary would call me, Auntie, meaning the Chinese are here. It was a Chinese contractor. They are sitting here. They say they want their money. But I've told them you are not. So you can't come out of the offices. So I'll be stuck in the office. I'll be stuck in the office until they get tired and then Vero will call me and say, they are gone now, so you can come out. But gradually we got the money. We applied to the Gates Foundation for 300 computers for the faculty. Not because the faculty would need 300 computers, but if we got 300 computers, then we will share them with some other departments or schools that needed. Unfortunately, I had to leave before they arrived. We set up a foundation in America, and every contributor to that foundation could take tax exemption on the contribution. So we raised a lot of funds in America. And the idea was our dollar fund would be used for the equipment, the technology, Wi-Fi, whatever that was needed. So, my take home is you need an environment that is conducive to teaching and learning. The situation is not the best. It's kind of like them, they have only one classroom that can take about 100 students, right? All the other classrooms are. So it frustrates the teachers, it frustrates the students. I don't know what the law village looks like. I don't know who conceived it and who is building it. But I hope you take some tips from our experience in the law school and do some drastic fundraising to make sure that it comes into being, because it is important for your purposes. I think I've said enough. If people have questions, I'll be willing to answer them. Thank you very much.
Please, another round of applause for Professor Queen here. I must admit, as one of the first, I think my batch was the first undergrad batch of students to study in this building, and I enjoyed my stay here. It was a good experience because we had the facilities available, and some of my students from the other courses, they were envious of the kind of structure that we had here, and we owe that to Professor Icflea. So please, let's give it up for her again. We'll have time for Q&A.
I was only an instrument used by the Lord to build this building. My private name for this building is the building that Jesus put up.
Well, then, Prof, thank you for availing yourself for the Lord's use. Please, another one for Prof. There'll be Q&A session. So if you have questions, kindly note them down. Those joining us online, please send your questions to the comment section on Zoom, Facebook, YouTube, and we'll send them to our panelists. Without wasting much time, we'll invite our second panelist to talk on human resource. She responds to the name Ms. Isabella Boateng, and she's from the enviable firm AB and David Ghana Limited. Please, let's welcome her as she talks on human resources.
Mr. Chairman, the Director of Legal Education, the Dean of the Faculty of Law, University of Ghana, Deans of the Faculties of Law, Universities of Lagos and Cape Coast, fellow panelists, distinguished ladies and gentlemen. The voices that erupt in the discourse on legal education in Ghana can be piercing to the ear, I know, especially for law schools, faculty, and regulators. The imagery that may be playing out in the minds of our audiences is reminiscent of the 6 blind men of Hindustan, who each view the experience of what they feel and touch as what is true, but who don't and may never together get to experience the whole elephant. But being a part-time lecturer myself, I know that the stakeholders in Ghana are extremely concerned about legal education, and it's a privilege to be part of the connected thinking, seeing the whole elephant on how we will transform legal education in Ghana. Distinguished ladies and gentlemen, the future of the legal profession is linked to the future of legal education. The human resource factor is easily the most important element of law practice. The quality of the human capital will define the practice of law in the public and private sectors, our faculties, our academia, and our judiciary even. And the thoughts that I'll share with you are largely a result of conversations I've had with myself on the character of legal education that I would like to see. These thoughts have also been inspired by recommendations from my colleague lawyers, students, findings of legislative reforms on the legal profession, my own experience as a lecturer at the Ghana School of Law, and my experiences as managing partner of AB and David Ghana, and from eavesdropping on the banter of our several stakeholders. Now, we all know what our mandate as lawyers is. We are the backbone to the rule of law, democracy, and the protection of human rights, including economic rights of our citizenry. Now, while this is central to our legal profession, we must also recognize the transformation that is beckoning us. And therefore, my focus in this conversation will be for us, 1, to take a second look at our mandate as lawyers. 2, to look at the inescapable trends and phenomena that engulf us. And consequently, the human resource we need to face the realities of today and the challenges and opportunities of the future in terms of us as lawyers, as faculty, and as stakeholders. And then I'll share some of the questions to consider on this journey to transformation. Questions around our economic mandate as lawyers, policy and regulation, admission requirements, faculty, and curriculum and methodology. Now, when I talk about this additional mandate as lawyers, what could that additional mandate be? You will all agree with me that the story of our legal profession has largely been mired in regulatory concerns, not about economic value, beyond the value that lawyers feel in their pockets. Understandably, our legal profession, which is over 60 years old, is not really in tune with the times. Now, if you look at our tertiary education strategy for 2018 to 2030, the whole idea is to build individuals to support economic and social development of Ghana. So how do we go beyond the regulatory issues? Now, our mandate as lawyers, we have to start rethinking that our mandate as lawyers, we have to go beyond regulatory issues. The legal profession could be a real sector. Now, we are participating in an 850 billion industry worldwide. If you look at the UK economy alone, they estimate that $37.2 billion pounds a year is generated from the legal sector. This has doubled in 20 years. And of course, a lot of it is attributable to the use of English law and to the Icflea arbitration system. But again, we need to rethink, what is that unique selling point about the legal profession? That could also be a selling point. That could be that instrument that brings economic value to us. Because the reality is that when we talk a lot about, financial resources for infrastructure, when we talk about the need for improved human resources in our universities and our law faculties, like Professor Kenya is saying, nobody really listens because nobody looks at the legal profession as a contributor, a real contributor to the economy. We just see us as contributor to social development, underpinning, law and democracy and rule of law. But what is your economic contribution? And that is one of the reasons why maybe our voices are not strong enough and have not been heard. So I want us to really take a look at that, where we see that it's necessary, and therefore it's necessary to see both the regulatory and economic value of the legal profession. Now, again, one other important thing for us to look at when we are thinking about the human resource factor is what are the trends and phenomena that we are engulfed with. And I'll look at 4 things: globalization, the new Africa, particularly the Afcfta, competition, and technology. Now, when you come to globalization, whether you like it or not, we are in a globalized world. Whether you view globalization as a tool for neocolonialism or you think that is a real tool for economic development, we are faced with globalization. Now, what does that mean for us as a profession? That means that you can find that a lot of times, increasingly, you are seeing multi-jurisdictional practice. What does that mean? What does that mean for the lawyer? And what does that mean for legal education in the future? If you're in a system where we are in a globalized world, where there's multi-jurisdictional practice, that means that your legal sector is open to other lawyers from other countries in a way, sometimes very subtly. So for those of us in private practice, and I'm in private practice, you see, for example, the onslaught of international law firms coming to do work discreetly and leaving, and coming to eat into our legal space. That is something that is really important for us to recognize. Because if, as I said earlier, we want to see the law profession as a contributor to the economic situation of our countries, then we have to be concerned about globalization and how that affects us. Then we also have to look at, as a result of globalization, of course, the opportunities and their risks that we need to consider. The other thing I want us to look at is about the new Africa and Afcfta. We are witnessing in a lifetime a vision that was birthed nearly 60 years ago. And what does that mean? We are talking about a 4 trillion GDP consolidated. We are talking of a market in terms of Africa, in terms of Afcfta, of over 1 billion people. We are looking at a private sector framework that underpins the Afcfta, and which in areas of transportation, natural resources, extractive industry will revolutionize the continent. How are we as lawyers prepared, and how is our legal education system prepared to have lawyers that will be able to face the realities of our times? And interestingly, if you care to note, we know that when we talk about Afcfta, a lot of times we're thinking about goods, but there's a phase 2 where they're going to be talking about services. There's going to be liberalization in the service area, and how are we as lawyers, and of course in terms of our legal education, prepared to take advantage of that? Now, it concerns me a lot because if we are not careful, all the fervor that we are all experiencing, the excitement of the new Africa, will end up only being about a recognition of our new African identity. But it will not go to how we can benefit economically from the Afcfta. And I want us to think about that when we think about our legal education. Now, technology. Technology is not a new phenomenon. Everybody talks about technology now because of how COVID sort of shoved us into the law firm of the future. But all the systems and all the platforms that we're currently using have always been there. 10 years ago, they were there. COVID just shoved us into the new reality. But we also have to recognize that technology also further enhances globalization. And if it enhances globalization, all the key issues, the risks and the challenges that I mentioned are also forefront. But whilst we talk about technology, we also have to take note of something very important. Law is a knowledge-driven profession. We also have to think about the risks associated with technology. And if we all remember, and it was a very, very big one, the Panama Papers. We talked about it in terms of the politicians whose names were mentioned in the reports, and we laughed about it and we moved on. But if you think about it, that this law firm that had become sort of the center of attention, that brought to the fore the fact that there's a lot of rogueness when it comes to offshore financial services. There was also a key important thing. How did that come about? It came about because there was a compromise of their technology system and their IT system, simply because of an issue of software. So I just want us to recognize that whilst we look at technology, we are excited about it, and we see the risks, the opportunities, we also have to be mindful of the risks associated with it. The other key trend I want also us to look at is about competition. Now, the competition is now within and without. Our local competition, and it's great. That competition is great because it pushes us as lawyers and law firms to do better in terms of our practice standards and in terms of our expertise. But the other thing that I want all of us to be mindful of, and when we think about legal education and we think about the profession, we have to also think about that, is the alternative service providers. You have, the KPMGs, the Deloittes, they're doing work that ordinarily was preserved. So how are we responding to that new onslaught of new service providers in our space? Then, of course, we have AI. Sometimes when we think about AI, we are thinking about Star Trek and all of that, but AI is real. If you work with international law firms, especially, I'll give the example of due diligence as a key example. By the time they come to you and ask you for a piece of work, they have an AI that has gone through hundreds of documentation, and now all they're asking you to do is to review the document that they have prepared for you, to just do an analysis and see compliance with Ghana law. That means that about 60% of the work that you would have ordinarily have done has been done already by the international law firm. So indeed, when we talk about multi-jurisdictional practice and how international law firms are eating into our space, it's a key thing to think about when we think about the future of law practice. Another key important point for us to think about is also Ghana as a destination point for dispute resolution. I'm sure all of you have heard of the Kigali International Arbitration Center, which is making waves. We have an arbitration center, but how competitive are we when it comes to Ghana being a forum for arbitration? Now, given all of that what I've talked about, what human resource do we need today and for the future? And when I talk about the human resource, I mean the human resource in terms of the lawyer that we are envisioning to have to be able to face the trends and the future that we anticipate, is beckoning us. So in terms of the law, in terms of the faculty, in terms of our bar associations, for example, what is the role of our bar associations in ensuring that we work together with faculty to ensure that we are providing, for example, practical training to lawyers to be able to become more responsive to the phenomena and the future of law practice. So what is the type of lawyer we need? The type of lawyer for now should be a lawyer who has an entrepreneurial mindset. It's not just about knowing the law. Knowing the law is at number 0 because it is assumed. Even though it is very important, it is assumed. So you know the law, you have an entrepreneurial mindset, a lawyer that has an understanding of industry, a lawyer that has commercial acumen. All of these are becoming very important in the market that we're in. And if you have as your competition, the PwCs, for example, you have accountants, you have auditors, and they are your competition, you cannot afford not to be a little more progressive when it comes to the shaping of the new lawyer that we require to be able to meet the demands of our future. And then what type of faculty do we need? Of course, a lot of the deans and the deans and the lecturers have talked a lot about that. It's not really my preserve, so I wouldn't get into that. But just suffice it to say that we need faculty that has experience both in theory and in practice, because at the end of the day, given all the phenomena I'm talking about, it's important that our young people, those who want to aspire to be lawyers, understand the future that they will have to face and be responsive to that future. Then I think that one of the key things that is also important is about training faculty to learn how to teach. When I started teaching at the law school my first year, the feedback I got, and I was very happy, that I think it was Marian and Juliet. The feedback I got was for my students was, she teaches as if she's doing a seminar. And that was because the fact that I was a lawyer and the fact that I understood law practice management did not necessarily mean I was going to automatically be a good teacher. And that was good feedback. And I think that it's important that even though we have lawyers who will be happy to volunteer, even though we can headhunt people, the need for a session on how to teach is also very important. And I want to believe that since then, my teaching capacity has very much improved. Then, in terms of curriculum, I go back again to phenomena. I go back again to the environment, the globalization, the technology that we are living within. Now, that should also influence our curriculum. So, for example, AFCFT is a big thing. It's a very, very big thing. In terms of our curriculum, how does that feature, for example? How does that feature in the different aspects of law that we are teaching our students? How does IT feature? How does legal writing and drafting feature? how does studies on thinking and analytical skills feature? All of these things are very important, and they are skill set that can be applied, whether you're in public sector, or in the private sector, you're on the bench. So these are, you know, across-cutting skill set that I think that our young people or people aspiring to be lawyers should focus on. Then practical legal training. I read a very interesting article, and I encourage everybody to read that. Mr. Kojo Benchelenshi wrote an article, I think, God of Blessed Mary, his soul rest in peace. There's an article he has written about the regulation of law practice in Ghana from 1893 to 2018, a very interesting article. And he's talking about the future of law practice as well. And he mentions that, yes, whilst we have our mandatory internship, whilst we have our pupillate system, we should, for example, with a mandatory internship, we should be looking at skill set that can cut across, that can be replicated no matter where the student is. So he says, for example, for example, that whilst it is good that the students are exposed to conveyancing and commercial transactions, we should also be very intentional about the students understanding analytical skills, legislative drafting, all of that, legislative writing, because that is a skill that can be applied no matter what the sector is. And I think it's also very important when it comes to the practical legal training, the role of our bar associations. Our bar association now, we have, everybody is a member of the bar. We don't have distinct sectors and sections in the bar. You go to other countries, and even if you want to use the IBA as an example, a section on business law, a section on public law, a section on legal practice management, so that people can come in and they can be, you know, associated with a team of other specialists, and they can learn from each other. And in that way, when we have our mandatory internship programs, when students go to those law firms, they will actually learn. Otherwise, what we've written in the regulations that they have to learn A, B, and C, they might go and they might never get the opportunity to learn that. So I think that is also something to think about. Now, I'm getting to the end of my presentation. Moving from the status quo that we are in right now to transformation. Now, the question I want to ask is whether the regulatory framework that we are proposing, and I know that we've all probably seen the legal profession bill that has been circulated, and I got the opportunity to review that. So I just want to have just a couple of questions that I think is integral and for us to start thinking about. Now, given the trend, the globalization, the competition, AFCFTA, my question is, does the act as it is, in the proposed act, the form that it is, will it support the future? Because if you think that the last time we had an act, a new act, was how many years ago? We need to have an act that is very forward-looking. And are we looking forward enough? I think that's one of the key things I wanted to. Then I also wanted to ask whether legal education should still continue to be the mandate of the General Legal Council, whether in terms of the composition of the council, I see there's an absence of deans of law faculties. Shouldn't that be something that has to be reconsidered? I see that in terms of the administration of the General Legal Council, there doesn't seem to be an envisioning of there being like a secretariat that is properly functioning with an executive secretary that will do the day-to-day. Otherwise, the General Legal Council will be like an, you know, twice a year or 3 times a year or a quarterly, you know, performance. And therefore, I think that's something I would also want us to think about. Now, in conclusion, I just want to bring our minds to something very important, key, and that's something that I learned in a leadership program that I just attended, and it's been very, very powerful for me. And that is that the key thing that people resist change. Because at the end of the day, whatever we're trying to see change in legal education in Ghana, the key thing that people resist change. What I learned was that people don't resist change, they resist loss. The fear of loss is what lets people resist change. So it's not the change itself. And therefore, if we want to do something about legal education in Ghana, in our thinking, we should always look at what is the loss here? What is the potential loss here? What is the potential loss for stakeholders? I was speaking to the dean from the Faculty of Lagos faculty, and then he was like, why don't we have a system where instead of, you know, having law schools, standing law schools, we do it like the accountants do. You go and study wherever you are. You come and write your exam, and then you go away. Why not? And I said, that's a brilliant idea, but I see the loss. The loss is the loss of financial resources. So whilst we give a brilliant idea, then each time we look at what is the loss so that we can all as stakeholders manage that loss and make compromises. So in closing, I think it's important that we need to confront what stakeholders would lose. We need to have a policy for legal education in Ghana. I asked before this session whether there was a policy on legal education in Ghana, and I was told that there was none. We need to have a policy that takes into account our vision for the legal profession and legal education. We need to be more attentive to the proposed Legal Profession Act. We need to be more attentive, because if we are not careful, everything will be passed and then we'll come and complain after. We have an opportunity to contribute, so please let's do that. Then we should be more strategic, whether in terms of our planning and having an action plan that we monitor and report so that we can all hold ourselves accountable beyond this conference. So ladies and gentlemen, I will end by saying that we no doubt, all of us, we've had permutations of Abraham Lincoln's great quote that the best way to predict the future is to create it. In this case, the creation may require a disruption. And interestingly, I saw a cover of a book, which I confess I haven't read. It's by Mark Shale. And the cover says, do disrupt, change, or be the status quo. So we have a crisis, but let's not waste this crisis. The crisis can be a good crisis and a great launch pad to do something different. Thank you very much for your attention.
Thank you. Thank you, Ms. Boateng. Please, let's give it up for her again for the insightful delivery by Ms. Boateng. What I got from her delivery was that in terms of human resources, law is just not knowing the law. We need lawyers with entrepreneurial mindset, understanding of the industry, and commercial acumen. And also, she made mention of 4 key areas that we have to think about when considering our contribution to the economy as lawyers. Globalization, the new Africa, whether as lawyers we are prepared to take our place in this new Africa. Technology, and we all know with the outbreak of COVID-19, we cannot do without technology. And then competition, in and out. We're fighting with AIs, other service providers, and law firms from outside the jurisdiction. Talking about technology, please, if you're here and you want to access the Wi-Fi, it's the conference Wi-Fi, and the password is UGSLAW@21. We'll continue with our discussion, and our next panelist also needs no introduction. He's a distinguished scholar. He's also the Dean of the School of Law, University of Professional Studies, to talk on institutional resources. Please let us welcome Professor Kofi Abuchi.
Thank you very much, MC. But in the presence of my former dean, you don't call me a distinguished scholar. Just as others have said, I was honored to be a student of Professor Kwenye here. But by some divine twist of fate, she ended up also being the director of the law school when I entered. So I was one of the few people she was dean to, and also the director too. And to ensure that I remain as a lawyer and not have my certificate revoked, I apologize for the scholarship part. But thank you very much. It's an honor to be here, and thank you to the organizers for this wonderful conference. I think a lot has been said today, and there's always a danger when you speak after other people who have spoken so well, the prospect of repeating things that have been said. I'm to speak on the issue of institutional resources for the administration of legal education, and I'll just say that broadly speaking, we have 2 key institutions, and these are the academic institutions and the non-academic institutions. The academic institutions, broadly speaking, we're speaking of centers of legal education, and these centers of legal education are complemented by centers of legal research. And so, for example, we have faculties or law schools in Ghana, and in addition, we also have centers that are just interested in legal research, such as the Institute of Advanced Legal Studies, among others. The academic centers invariably must come with certain minimums. And these minimums are libraries, law libraries. Time and often has been stressed that a law school without a library is no law school at all, because the legal profession prides itself in having a library or in operating with libraries. The question of the character of libraries today is one that demands debate, because traditionally we are used to spaces that have books, and these books, among others, sort of massages the egos of lawyers. There is nothing prouder for a lawyer to have either law chambers or any point where he practices from, and the place is littered with law books. Very often they are not read, however. But they represent good decorations and reflects what he would want to advertise as the tools of his profession. The question is whether today we are ready to accept non-physical law materials. And I dare say that this area has remained contentious. The Accreditation Board still insists, indeed the General Legal Council still insists on seeing physical law reports. They still insist on seeing physical law materials. Yet we are apparently in the days of the technology or the soft materials. And the question is whether a law school can exist without physical materials, but can just say that our materials are all out there in the air and our students consult them. As the world continues to go through a pandemic with all the complexities of the adaptation, I think the time has come for us to make these sober reflections. But of course, it's imperative for us to also understand that people can play around these. And that partly explains why there are concerns about the idea of supposedly just operating a law library which is entirely virtual. But the basic minimum is that a law library is indispensable to the operation of a faculty of law. In addition to law libraries in an academic institution, one must have other teaching resources such as moot courts. A moot court is an important component of legal education in Ghana, indeed globally. The reason that is because practical lawyering is supposed to be an integral part of the training of a law student from day one. We do not have to wait until students are in the law school. And I dare say that even in the law school, the content of advocacy is not really what it's supposed to be. And this has been the case for a long time. Perhaps today it's even better with the introduction of internships. But the reality is that the same difficulties of infrastructure, the same difficulties of hard infrastructure that Professor Kunyi here spoke about earlier, confronts the law school. And indeed, the director of the law school also mentioned similar things. These realities imply that faculties of law must continue complementing the law school, but by starting training in practical legal advocacy from day one. The truth is that this is expensive. Creating and establishing a moot court facility that comes with a full complement of the things that are required for practical lawyering and advocacy is expensive. And very often, law schools themselves are struggling with inadequate resources to ensure that they provide other necessities of the education, and these are challenges that have to be recognized and understood. In addition, within the context of the legal education, at least within the schools, again, Isabella mentioned the issue of human resource. And indeed, the director of the law school also mentioned that. We need well-trained people. The truth of the matter, and this is something that we cannot ignore, the truth of the matter is that very often we do not have adequately trained and sufficient number of those people in terms of lecturers. We have basically reduced legal education in terms of training or teaching to people who hold a master's degree in the minimum. The fact that I hold a master's degree is no guarantee that I'm a good teacher. Indeed, the fact that I have a PhD or a professorial title doesn't mean I'm a good teacher. There are people who are very good in writing, but are not good in impartation. As Isabella also mentioned again, the fact that she was a good advocate and a very good practitioner gave her a culture shock when she went to the classroom, and she had to adapt, and as she indicated, today she's a better lecturer. All of us can go through that socialization process. But the truth is that because we have such a dearth of people with the requisite competency in teaching, the art of teaching, the training to teach, and indeed the calling component is the poverty component, because that's the part that says you'll be paid in heaven. Hopefully, we are not waiting to be paid anymore in heaven. But the truth of the matter is very few people do have the calling for legal education and for teaching. But because we have such a dearth of materials in the market, we are all forced to settle for the few we have. And because you have faculties of law now who are scrambling among themselves and cannibalizing on each other to ensure that we have the requisite number of teachers, we basically just take anyone who comes, anyone with a master's degree who is interested in teaching. We are forced to hire them. This represents a major challenge since human resource is such an important component of the entire training portion of lawyers. But as I mentioned this, it's important for us to also remember that as we speak of legal materials, particularly for libraries, what character or quality of legal materials do we need in our libraries? And at this point, we need to have an introspection. There must be some soul searching. There must be some acknowledgement. Legal education in Ghana has taken the path of what I call the submissive approach. The submissive approach is the one that says the teacher is a god. What he says is right. He makes no mistake, and when he speaks, the students listen. The student is submissive. He studies and spends his whole time trying to understand the pattern of the teacher. And he tries to ask students who have gone ahead of him what this teacher likes. That student specializes in pleasing the teacher as opposed to trying to understand, imbibe, and as it were, internalize whatever he's taught. The submissive approach is one that rewards submission. It's one that rewards the obedient students. That is the path, or that was the path when I was a student. It was the path when I was a lecturer. And many people have continued to promote this path of legal education. And the truth of the matter is, very often our students don't come to our classes ready for scholarship. They come to our classes ready to know what we want, and they give it to them, because that has been the culture or the path for so long. It is also therefore important to note that as we try to speak of using materials that are used elsewhere, the Westlaws, the LexisNexis, and others of this world, the truth is these materials are often very much conducive to the Socratic approach, as the Americans call it. The approach that leads to critical thinking, the approach that interrogates, the approach that challenges you to think. But if you are applying a submissive methodology or pedagogy in this environment, and you are asking students to refer to the Socratic material, you're going to create a conflict in approach. Because these students are going to have material that challenges them to think and go beyond boundaries, to go outside the box. And then when they come to you, you pretty much are asking them questions that compel them to be obedient and rewarding them for the obedience. So these are things in the soul section that for those of us on the side of legal academy or legal academia, we should do the soul searching and ask that hard question and go through that reformatory process. Otherwise, we'll continue to churn, not churn is a bad word, we'll continue to produce students who are, as it were, just obedient in a world that is not ready for them. Because the world today rewards people who are creative and who can challenge the order. And I have to be honest to you, I have seen generations of our students go to international moot courts, and I see a clear difference between our students and foreign students, particularly when it comes to the issue of confidence. Our students are very happy to be submissive. Other students are challenge the order, and it's important for us to note this. Now, as I go to the non-academic institutions, an appropriate regulatory framework is necessary. I'm not going to belabor this because the point has been well established or articulated by speakers ahead of me. Perhaps we have gotten to that point where the regulatory environment must begin to respond to the challenges that it has. The truth of the matter is this: we cannot liberalize legal education in a populist manner. We have had, and I have been accused on many occasions, because there are some things I barely speak on because you can never win. Every side, whatever you say, you are likely to be unpopular with the other side. We cannot regulate legal education in a populist manner. The populist manner being the manner that appeals to the popular sentiment. Legal profession, like all professionals, have minimum requirements, and everybody must meet these minimum requirements. So the question has been asked: are we ready to liberalize, popularly speaking, the medical profession? I'm sure many of us will not be happy or will not be comfortable if we are about to be operated upon by doctors and surgeons who qualified because, quote and unquote, the floodgates were opened. Everybody must have equitable or equal access, but that equitable or equal access must be predicated on quality. So it's important that we open the gates. It's important that we establish equity It's important that we establish equality, but it's important that these are predicated on quality. The problem, and this is where the criticism comes in for those involved in legal education, the problem is for close to 50 years and more, there was virtually no reform. Indeed, one will argue that until the establishment of the Faculty of Law in KNUST, there was only one Faculty of Law here in the University of Ghana where I was privileged myself to have had my legal education. And until then, legal educational reform and regulation was not a subject. It was not an issue because the numbers were so small, nobody cared about anything, so to speak. Until KNUST came along the lines, and just as we had in the first educational reforms of the GSS, SHS, when we were about to produce the first students from the KNUST, I think people started asking questions whether these were also law students. Because before then, nobody could think of law students coming from any other place apart from Legon. So these shocks have created the current situation in which we are, an environment in which the regulatory framework is beginning to react to a situation that it has really quietly watched evolve and fester for some time. But the issue cannot be resolved by also stampeding the process or stampeding the system and pretty much just saying, open the gates, allow everybody in, regardless of the standards and the consequences of these standards. So the regulatory framework has to respond. Some have called for the establishment, perhaps, of a legal educational council or something to that effect, something which specifically focuses on the issue of legal education and nothing more. But we have gotten to that point where perhaps there's a need for some hard questions to be asked. Because the truth of the matter is, and again, Isabella drew attention to that point, and I've been very passionate about this part. Because we are so distracted, there are a number of problems happening in Ghana no one is paying attention to. In fact, all the issues, Isabella, you mentioned, are issues I've spoken about before, and it's almost as if we listen to each other. I remember about 5 or 6 years ago at the faculty bench bar conference, I presented a paper on the legal market in Ghana. And what she said, it's, we are distracted by other things because of that fundamental things like foreigners practicing in Ghana. There are others who come from other jurisdictions and set up offices in Ghana. They either get called in Ghana or they don't get called in Ghana, but they employ Ghanaian lawyers pretty much to man that office, and then they sit somewhere and then they operate, in Ghana. Look, the truth of the matter is AFCFTA has opened the gates. And we are not being careful, we are not even paying attention to that. Under the AFCFTA, not only goods, but there are services components. And very soon, lawyers can practice anywhere in Africa. And sooner than later, that market that one would expect there's protection of, that market will be opened and exposed for competition that we may not be ready for. The simple truth of the matter is it's imperative that we open our eyes. And I think at this stage, we are probably distracted by the chaos and the confusion characterizing legal education, which is making people call for all kinds of things. But it's important that we remain measured. We should remain measured from the regulatory standpoint. We should remain measured from the student standpoint. I think any extremist position will not be beneficial to anybody. Then as I draw to the end of my presentation, I'm just going to mention 2 quick things which are also non-institutional within legal educational setups. And that is one that is quite dear to my heart, and that has to do with mentorship. Now, mentorship is important, and there's something that I would say, but I'm sure I hope people don't quote me. But I nearly became a dropout law student. And the reason I nearly became a dropout law student was because I basically got my first 2 grades in law wasn't what I was expecting. And so and the ones that without mentioning any subject, but the ones that law students used to read other courses, not only law. It was a combination of, because we had law, but you could read sociology, political science, psychology, archaeology. You could read other courses. The other courses that, without disrespect at all to any course, but the other courses that I wasn't paying as much, I wasn't devoting as much time to, I was excelling. I was a bit traumatized. So I went and spoke to one of my lecturers who is still a lecturer here, and I will mention it to her glory because she kept me in, Mrs. Dona Amond. I went and told her that I was thinking of quitting. I think I'll do better in the other courses than this course, which had given me some grades I wasn't happy about. She mentored me on the need to stay the course, on the fact that I wasn't the only story, and that there are worse or similar stories. So just stay the course; it's going to get better. Eventually, the rest is history. I'm here, but just to let you know that there are many law students whose dreams die along the way, simply because there are no mentors, simply because there's no one to speak to. And there's so much frustration and there's so much anxiety, especially now that people finish the LLB and the way is not clear beyond that. It's imperative that we have institutional systems. We should institutionalize mentorship within faculties of law. Mentorship that probably goes along the lines of counseling as well. Because we have so many people, and this has nothing to do with age, but we have other people who may be struggling and may not be necessarily mature. And the maturity here, again, as I said, has nothing to do with age. We all mature at different levels, and there are different people with different emotional and physical maturity capacities, and it's important that people have outlets whenever they face such challenges. Finally, on this, the gamut of institutional structures that we need. The bar. The bar needs to take interest in legal education. It's important that the bar remembers that lawyers are produced from law schools, and very often the bar is outside law schools. Sometimes when you have a program and you're looking for the bar to participate, the bar is aloof, not interested. Pretty much, it's your own thing. We have a system in which a poor input will result in a poor output. And the earlier the bar recognizes that legal education is the direct feed that gives lawyers, and as was put earlier, if lawyers are not well paid, but then you have people who are outside the law, you meet your students, your former students, and their salaries are twice or three times your salary, and then you ask yourself, as someone said, if you don't make heaven, then what exactly happens? You have not been paid here, you have not been paid there. But then you start asking yourself these soul-searching questions. But it's important that the bar recognizes this. I must say that perhaps it's gotten a little better in recent times. The attempt at even establishing the faculty bench bar conference, all these indicate attempts at creating those synergies that are supposed to exist between faculty as faculty, the bench as the bench, and the bar, of course, as the bar. But we still do not have an optimum level of cooperation, an optimal level of relationship between the bench and the bar. And all these problems that I've indicated, between the bench and faculties, and all these problems that I've indicated, these are problems, many of which can actually be helped if we have a good relationship with the bar as the direct beneficiaries of legal education, whatever lawyers are produced. I've been advised on my issue of time. It's been an honor. I'm sure we'll take the questions and we'll have an interaction accordingly. Thank you.
Thank you, Professor Abochi. I mean, listening to him talk, with the permission of Professor Kwenya, we can agree that Professor Abochi is a distinguished scholar. May we give it up to him again? So, he touched on academic and non-academic institutions, which are key institutions in our legal education. And for the academic institution, what I took from his talk was that we as lecturers, we should reform our way of teaching. And for the non-academic, our regulatory environments must be responsive, but not in a populist manner. Even though there are floodgates, there are a lot of people who want to enter law school. We should ensure equitable and equal access, but it must be based on quality. And also the issue of mentorship. Some of us were privileged to be mentored by some of the lecturers here, and it's our hope that after this conference, the mentorship program will be institutionalized in Legon and elsewhere. Still on resources for legal education, it is not just a conference in Ghana, it's also a conference, a legal and international conference for Africa. So we are privileged today to have from Nigeria, the Dean of the Faculty of Law, University of Lagos, Professor Ige Bolodeku, who will be giving us a talk on financial resources.
The chairman, distinguished speakers and panelists, distinguished guests here, seated, distinguished students, ladies and gentlemen. As a dean of faculty, of a law faculty, I think I can readily relate to issues of resources and funding resources, because I have a student population of about 1,700 students in the law faculty, and the faculty capacity is about 56, 17 of whom are professors, 6 associate professors. We have 10 senior lecturers, the others lecturer 1 and lecturer 2. So some of the problems that we face in administration are within our reach to conquer. Some can only be done either through activism. The other outside your reach, perhaps by lamentation. You continue to lament because you can't deal with it. Now, and I'm happy that I'm actually being called upon to speak about resources, about funding resources, that is the financial resources. So where is the money? Let me thank the organizers for inviting me as the Dean of Faculty of University of Lagos to this conference, and I'm actually really glad to be here. I've learned over the 3 days we've been at this. This is the 4th day. Now I will start this. That we just heard from fellow panelists discuss the various resources that are required for a 21st century legal education. On the one, we heard about the imperativeness of policy for legal education, which would provide, by and large, the roadmap for bringing to life the sort of legal education we hope for. A comprehensive policy thus sets a stage for its actualization. Actualizing a viable policy for legal education should ordinarily begin with a proper curriculum and the methodology for its delivery. On that, we all heard the voices of experts on day 3 of this conference. With the right policy and curriculum for its implementation comes the resources needed to turn policy and curriculum into developmental tools. My co-panelists have articulated the requisite resources. What is left, therefore, is the financial resources, which are key to all of the efforts put into this conference. So I ask the question, what sort of financial resources do we need to achieve a legal education of our desire? One that can transform and develop the capacities of law students with enormous accretion of value addition to every stage of the value chain or the ecosystem of legal education. Why do we need to create awareness about financial resources? Simply, all the resources identified earlier must be funded. Then we go on to where we may get the money. First, we look at government subvention. The overall superintendent of education in any country is the government. It should not matter whether government owns schools or it does not, since education and its policy determines the level of development of the country and its capacity to cope with the challenges it faces. If government owns schools, it must fund them. For schools owned by private persons, government must provide for schools owned by private persons, government must provide the standard for investing in such resources that the private organization may apply in delivering an acceptable qualitative education. Education spending as percentage of government spending in Africa in 2018, Ghana stands as number 13 in Africa with 18.6%, with Sierra Leone, Burkina Faso, and Togo occupying the first 3 positions. In the same year, education spending as a percentage of GDP, Ghana stands at number 18. The first one was number 13 on GDP ratio to spending is number 18 in Africa with 3.99, with Lesotho 6.99, Sierra Leone 6.99, and South Africa 6.1, occupying the first 3 positions in that order. In 2020, this increased to 6. The spending of Ghana increased to 6% of the GDP. And in 2020, Ghana approved the education budget was 13.3 billion, which was approved for the education sector. That is 13.3 billion cedis. Under Chapter 5 of the Ghana Constitution of 1992, Section 25, as amended, deals with educational rights as a fundamental right. Subsection 1 provides that all persons shall have the right to equal educational opportunities and facilities, and with a view to achieving the full realization of that right. Higher education shall be made equally accessible to all, the section further provides, on the basis of capacity by every appropriate means, and in particular, by progressive introduction of free education. This provision therefore identifies the government of Ghana as a constitutional finance resource for higher education. This implies also that the government must devote adequate financial resources to provide the resources needed for the enjoyment of that right, that is educational rights. Educational rights is what it is. Pertinently, it is a justiciable and enforceable right. This is where some activism may be needed to push the enforcement of this right to its limit by relevant stakeholders. And then we may ask, if there is provision by government on education, what would be the basis? If indeed government has the responsibility to provide education at the level stated in the Constitution, then provisions made by government must be informed by needs assessment. Because if there is no needs assessment, any amount of money devoted is whimsical. It's not based on facts, and it may not be able to provide the kind of qualitative education that is required by the Constitution. So, and this is the area where I talked about activism to push the limits of these particular rights for courts to know and sketch out the principles that may be applied in enforcing and achieving the objectives of that particular provision. Ultimately, it may come down to how a government prioritizes education in connection with its social, political, and economic development, given the nexus between quality education and human capacity development. And interestingly, Section 2 of the Ghana Constitution provides another dimension to this issue of educational rights, or other rights indeed. It focuses on the modality for the enforcement of rights under the Constitution, where an action may be taken, the sort of order the Supreme Court may make, and the consequences for disobeying the orders, and the directives given by the Supreme Court. It will take, again, rigorous activism by stakeholders to enable the Supreme Court to set the strictures of the education rights established under Section 25 of the Constitution. So, as I said, we had identified government as a financial resource. But as has been mentioned here today, government can't do it alone. There are so many things government could do, but there has to be some support system to fund education. When I talk about the Special Education Fund, again, this is an initiation or perhaps initiative of government. And I'm sure we are aware that Ghana has the Education Trust Fund, GET Fund for short, established by the Ghana Education Trust Fund Act of 2000, amended by an amendment of 2018. The act imposed a levy of 2% on supply of goods and services made in the country other than exempt goods or services, and also 2.5% on all imports of goods and services other than exempt imports. It is calculated on the value of the taxable supply of goods and services and the value of imports of goods and services. While this is a great financial resource for education in Ghana, the utilization of the fund is on education in general. As a result, higher education will compete with other levels of education in fund utilization and allocation. The allocation or sharing policy of the fund does not seem to be clear. But we may perhaps borrow a leaf from Nigeria in this regard, because Nigeria also has the Tertiary Education Trust Fund, TET Fund. It used to be like what the Ghana system is now, framework is now, until in 2000 when it was now focused specially on tertiary education. In its 2019 report, we had 87 universities, 65 polytechnics, and 71 colleges of education, all public institutions benefiting from the fund. The source of funds for the fund is 2% of the assessable profits of all companies registered in Nigeria who are liable to pay income tax under the Companies Income Tax Act and the Petroleum Profit Tax Act. And in its 2019 annual report, the TED Fund received a total sum of 221,304,417 billion naira. Yes, and from 2011 to 2019, the fund has received a total of 1.7 trillion. Boards of trustees is created for the management and application of the fund consistently with the statutory mandate, which include essential physical infrastructure for teaching and learning, institutional materials and equipment, research and publications, academic staff training and development, and any other need which, in the opinion of the Board of Trustees, is critical and essential for the improvement and maintenance of standard in the higher education institution. All of the above interventions areas are regularly funded, especially physical infrastructure, staff training and development, conference attendance, library intervention, information and communication technology, academic research journals, publication of manuscripts as books. Perhaps Ghana may consider a special trust fund only for tertiary education to maximize, to maximum impact. Now, I just quickly want to note that if government funds education and education is not properly funded, then there is going to be, there are bound to be problems. One problem that we may face is that if education is not properly funded, then the academics that sustain the training of lawyers or any category or any discipline in the university sector will also be poorly paid. If they are poorly paid and they face humongous number of students yearly and it's incremental, what level of motivation may we expect from them to really discharge these responsibilities? And by the way, so what it will mean is that if qualitative education continues to exist where there is poor funding and government is not covering up, then that education is being subsidized and someone is paying the price, because quality education is a service and it must really be paid for. So if you are lucky to have qualitative one and you are not paying as much for it as you should, then someone is subsidizing it. I've always thought that law lecturers or any lecturers that taught in university are the ones paying for education in so many countries. They are the ones paying for education. It is not free. Even for Nigeria, where it is said to be free, it isn't free because it is not properly funded and lecturers are not properly remunerated. But quality is still being achieved at some level. Then the third source of financial resource is alumni donation. Alumni is key. I am speaking from personal experiences as Dean of Faculty because over the last 8 months that I assume office as a Dean, I've had meetings and contacts with our alumni associations simply to get them involved in this particular issue of funding. Why diverse donors may contributors to the university, a core contributor donor to university are alumni. Records have it that in 2018, alumni contributed about $12.15 billion, or 26% of the $46.7 billion raised by the US colleges and universities in 2018. This amounted to an 8.6 increase over the figure of 2017. At the heart of the success recorded in alumni contribution are the innovation in establishing contact with alumni and maintaining that relationship. There has to be a system of communication or relationship with alumni in a way that induces, their desire to make contribution to their alma mater. It is imperative, therefore, to invest in ICT and deploy it in keeping in touch with the university alumni. Alumni office must be creative and face this area as a project with target achievements. What is the alumni culture among institutions in Ghana? Are the alumni contribution a factor? Can we make it a factor in our drive to tap into the financial resources available to universities? of course, we had the professor who God used to build this edifice. What effort she made personally, out of creativity to ensure that this building was built. And we thank God because we are all here enjoying it. I've had it by University of Ghana, Legon, but I never knew. But today I now knew, how this building that we all talk about came about. And thank you very much, ma'am, for your effort. Now, the other aspect of financial resource is tuition. Tuition represents the critical mass of revenue for the university for planning, administration, and for the provision of infrastructural needs for qualitative education. The issue of tuition, or the right tuition, is a sensitive one, especially in public institutions. It is often political coloration. It often has political coloration in the formulation of policy and the amount of tuition that should be paid. To serve its purposes, though, tuition has to be properly priced. Pricing must be based on needs assessment of what are required to operate a 21st century university. In essence, the needs must include the resources my co-panelists have discussed in their presentation. Tuition must cover cost. If the tuition fails to reflect needs, and if it is not cost reflective, education, and in this regard, legal education cannot be qualitative. If it is either that government adequately funds it or the subsidy is from somewhere. I had discussed this issue before. Now, I went through the internet to see the averages of tuition that are paid by university in Ghana. And I see from 1,000 cedis to 2,000 cedis for a category, and then for the international, perhaps a little bit higher. But going through all of that, except for few of the private universities, I then began to wonder how this kind of tuition can actually make substantive impact for qualitative education. Now, there is nothing wrong in fixing the right tuition. And as a matter of fact, it is a dereliction of duty not to fix tuition appropriately to be able to reflect the cost of maintenance, the cost of expansion in infrastructure, and the cost of sustaining one that is on ground. And there must be room for recreation, regeneration of the faculty, and also, to improve this, the issue of standards. Now, what is problematic, though, is that if tuition is properly priced, it may perhaps be fairly prohibitive to so many students. But that is not the end of the story. What happens is not the high cost of tuition. It is what government may do and can't do to ensure that these tuitions are paid. Because if it is emotional, if it is sentimental, what it will mean is that university will receive inadequate amount of funds and they will not be able to operate qualitatively. And in this regard, my own suggestion is that government may step in to ensure that every student has access to education loans. It has to be available. And once the loans are available to students, then the fees will come as a critical funds or revenue to the university for their own planning, because every year university must budget for what it needs, and therefore must be able to charge that amount of money that they can operate with and also improve on their own systems. So if this is done, then what will happen is that some parents will pay the tuition for their awards. Those who can't afford it, may have to take loans. And there will be some repayment modalities set by government, either some months of moratorium and all that. But ultimately, the discussion comes down to what if students don't pay after graduation. And to that, there is always an answer. We have a system of BVN in Nigeria where all bank account holders have an identification number. So if you have 10 accounts, all your accounts are linked with your BVN, with your picture, and of course your biometrics. So the possibility of getting out of school, working, and defaulting is there, but also with your BVN, if it is in the system, you are traceable. So if you are defaulting and lying to government, they can find out, and they can help themselves to your accounts if you are responsible, but you are not living up to your responsibility. Apart from tuition, we have research grants. Research grants are also, a very veritable source of funds for the universities and for legal education. There are financial resources available to tertiary institutions. Universities should therefore transit from being only academic institutions to research institutions. Writing research proposals that can attract grants requires special capacity for grant writing. It requires a new awareness, a new realization that researchers are meant to add value to society and to place the institution on a high pedestal of global recognition. Above all, they help government to formulate viable policies for development. The act of writing winnable research grants can be learned. It is noteworthy that research grants provide a source of earnings for grant awardees. They motivate academic excellence, add value to society, since they are often focused to help solve problems or call attention to problems areas needing intervention but often overlooked. To be susceptible of winning research grants, universities must put in place the proper institution to promote research grant writing from donors around the world who are willing to provide grants to aid research within their areas of focus. Now, doing so may require the setting up of Research and Innovation Office under a director with administrative support who may create a research writing culture and nurture it to enviable height. Research grant writing, for the avoidance of doubt, is not limited to sciences. It extends to humanities where law belongs. In the University of Lagos is neck deep in research grant writing with the requisite administrative structure and personnel in place. In the last 3 years, the university has attracted over 15 billion naira in research grants. So that is also an area that universities should be looking at, law faculties should be looking at. The grants are out there, there are donors. All we need to know is what their focus areas are.
order to buy a paper 10, maybe 5, 10 years down the line. So they have 10-year-old children and they are competing with their alma maters and they hope that when admissions and certain things come out, favors will be made. So how do we particularly balance the independence of higher education institutions, particularly law school, when we are seeking funding from private interests and alumni in this respect? Why don't we maybe 3 more questions, and then I will answer all of them together. Can we see by show of hands if you have a question? That's one here, that's 2. I have a there. Oh, so we have 2.
Thank you so much, Mr. Chair, for this opportunity. My name is Wanta. I am interested in libraries. Specifically, all the panelists have pointed to the fact that libraries are indispensable. Dinabochi said that libraries contribute to the academic activities of law school. The only thing I want to add over here is that normally when people talk about libraries, the focus is on only academic libraries. But in every Commonwealth jurisdiction, we have about 6 different types of libraries, which range from academic libraries, law firm libraries, judicial libraries, etc. But the focus in our jurisdiction is only on academic libraries. And it leads to some of the academic law libraries are not properly or have not been properly managed. When the professor from University of Lagos spoke, he also talked about that. And we realized that the University of Lagos, University of Ghana, University of Ibadan, and then University of Nigeria, Nsukka. All these libraries were first generation. All these universities were first generation universities that came after independence. And their law libraries, as of today, have not been properly looked at. We have the same thing over here. Simply because in a legal jurisdiction, as I said, the concentration is always on academic library and not the rest that I mentioned. Sometimes, even the states, those that even have spaces to operate, they don't have fit for purpose, like the way you mentioned. They don't have fit for purpose library. Now, the University of Ghana in 1961, when it was set up, did not she has to move to get a library of this nature in place that we are enjoying today. But even after getting it, how do we maintain it? And how do we look at the other libraries that are crying for help? Madam, let's say APA also Isabella. Madam Isabella also talked about the GBA. not pushing things enough, especially when it comes to organizing or pushing things for members or things that affect members. She likened it to the American Bar Association. The American Bar Association is always proactive. In fact, if you look at how they organize their libraries or the effort that they put into the organization of their libraries, they have what we call standard of procedures, and in it, they set up even the type of sorry. Actually, this is a problem. I was looking at within a slot to talk about law libraries because we are talking about how we can project. How we can project law libraries or how we can project other institutions, that are stakeholders. You see, in higher education, for the next 10 years or so, by this slot, you see, don't worry. So, there are a lot of things I'm passionate about, Thank you so much. But let me end. I would like to end, by saying that, like former King said, libraries thrive on donations. Yale Library, for example, was given to by Son Goldman, who gave $1 million that the library should be named after his wife. So Yale Library is also known as Lillian Goldman Library. So I will urge all that libraries and other institutional facilities that promote legal education are on sale here. The library there, Alain Dinabochi will buy our library. So that they will help. So I'm calling for donations as well. But I'll give my other contributions in writing. Thank you so much.
I think we'll do a whole new, conference on libraries. So don't worry, we'll do that on law libraries. So don't worry about that. We'll do that. All right. May I, at this juncture, recognize the presence of Justice Professor Mensah Bonsu, who is here with us this afternoon. Please, a round of applause for that.
Thank you very much. I don't think 30 seconds will suffice for the number of questions I have. So I have 3 questions. 2 as a final year student, with the reasonable expectation that I make it into the Ghana School of Law next year. So 2 of my questions will be directed at Mr. Kwesi Prempeh-Ek. So firstly, he mentioned that following the exams that were written this year, the entrance exams, 790 have been admitted plus 499. I just wanted to ask, what are the modalities in place for the admission of the 499 to begin? And are we, as prospective entrants into the Ghana School of Law, going to be affected by this number that has been added on? Are our numbers also going to be rationed? Are we also going to experience some sort of cutoff in the manner that we experienced this year? My second question is also that we hear of our seniors in the Part 1 talking about their lecturers not being present in class. Some have mentioned some of courses like LPM. We don't even know the full names of the courses. After paying these huge amounts, 15,600 cedis, which we are also hopefully going to pay or even more next year, how is the Ghana School of Law addressing this issue? After paying that amount, and let's say a lecturer comes to class the whole semester just twice, how do they address these issues? My final question is directed to faculty members on the high table of the University of Ghana School of Law. Dr. Tupare mentioned harmonizing the values that our legal education should symbolize and making sure that the people that we are training embody these values. Now, as a student leader, we have tried to address the challenge of grades and gauging students' performance. And we engaged the patron of the union, Dr. Mantiao, on having an examiner's report to be able to assess the performance of students and know the expectations from them. But we realized that different lecturers expect different things. And that resonated with the comments of Professor Bochi about submissiveness. And if we are in a culture that is engaging scholarship, engaging the quality of your thought process and not necessarily following a particular pattern of answering the questions. Because we realize some lecturers just want to see some particular things. Some want to say, if you don't do an assembly of law, you have automatically lost 30 points or 30 marks. Meanwhile, the quality of your argument in your essay could attract an A. But simply because you did not produce that particular method of answering the question, you lose those marks. Those marks, I beg your pardon. I want to ask that how are we addressing this issue going forward? Getting feedback for students to know what is expected of them really when they are answering their questions. And whether varying from lecturer to lecturer, we can be able to harmonize this so that the same way you would answer this particular essay question and get an A, it's not the same way that you would also answer another particular essay question and get an A. Thank you.
All right, thank you very much. Mr. Chairman, I will, with your indulgence, I will go ahead and, as part of the host of this conference, take the very last question that was asked with respect to how to answer questions. Let me say that this has come up many, many times. And what I'll say about that is that, as you are very much aware, we are training you to be part of a profession. And there are certain things that you must do when you go out there and you are practicing. So I'll give you an example. You cannot answer a problem question and not raise issues and address them. If you go to the court and an action is filed, you cannot go all the way, to a trial without having to know how to raise issues. So we keep on saying that the way you are being instructed is essentially mirroring exactly what you are going to do out there. So it may be sometimes very laborious. And when I was in your shoes, I used to question that all the time as well. Why must we do it this way and not any other way? But as you will find out very soon, there are rules by which the practice is governed by. And we do not dictate those rules. The rules are made, and we are to instruct on the basis of that. But I'll tell you from experience, and Professor Justice Benson Bonsu is here, that even at the Supreme Court, there are a lot of people that struggle with raising issues. It's one of those things that, look, it follows you all throughout your life as a lawyer. For as long as you are going to end up as a practicing lawyer in court, and even when you are doing business law practice and all that, you have to write legal opinions and all that, there's a certain format in which it must follow. So there's a good reason as to why we insist that you answer questions in a particular way, because that is exactly what is going to happen when you leave here. Thank you. Let Professor Wuchi then after you, yes. Sorry? Very well. Prof, then just 1 minute, okay.
Honorable Justice Dr. Binekama, University of Sierra Leone, Fabe College. Now, my leadership clearly addressed this issue yesterday in articulating a point regarding the conduct of examinations and assessment. She made it very clear that what is required is critical thinking, introspection, and analysis. Now, when scenario-based questions are given, all you need to do is to look at the scenario. It contains a plethora of issues. There is hardly any scenario-based question that is restricted to two or three principles. Examiners are so catchy, they will couch the question in a way that every word, every sentence, every clause in the scenario contains a legal issue. And every legal issue is regulated by a legal rule. So as a student, it is expected that prior to examinations, you ought to have recorded a plethora of legal rules in your mental notebook. So when you come to write the exams, having read the scenario, single out the issues. Look at the legal regimes of the Republic of Ghana relating to those issues. Apply those rules to those issues. In instances where there are exceptions or exceptions to the exceptions, you come in with the exceptions and the exceptions to the exceptions. And that will lead you to the conclusion. And then you conclude by advising the persons you are told to advise in the question. I thank you.
Okay, so just very quickly, but let me just start with the last one. I think, just so I'm not misunderstood, the critique of the submissive model of teaching is not also a call to rebellion. In other words, being disorganized is not a mark of freedom. It's not a mark of liberty. So the fact that I'm asking that we should begin accepting critical pedagogy doesn't mean I'm saying that, in other words, you can start answering a question with a conclusion at the beginning. That is not a mark of freedom. So it's important for us to just pay attention to that. But the question of admissions and funding of legal education, that's extremely important. The scandal that broke out in the US recently that I think you were referring to, they called it the admissions scandal, was bad, especially for the Ivy League schools, where it became apparent that people were basically buying their way for their awards. We have to balance a number of things, and we have to do a number of trade-offs. In this country, if you're asking government to fund legal education, let's be honest, it's just not going to happen. Other sectors of education are crying, and they're not even getting adequate funding. So that's not going to happen. We have to charge some fees, but fees must also be indexed to the market. And that's part of the things that I mentioned earlier, Isabella was speaking about, because there are studies to show that in the US, admission numbers dropped drastically about 5 or 6 years ago. And part of the reason for that was because the job market was simply not there. And so a lot of people were graduating from law schools with a lot of debts. Some of them owe more than $100,000, and there's no job for them to do. So applications to law schools dropped, and invariably with that will come the financing, the funding of legal education. So a lot of balancing has to happen. Some fees will have to be paid, and there must be increments moving forward. And some schools are charging commercial fees. But at the same time, this must be balanced with the fact that there's an availability of jobs. Otherwise, sooner than later, applications are going to go down. And with applications going down, particularly for private law schools, they are going to struggle to even survive. Finally, the issue of libraries. I would just recommend, by way of suggestions moving forward, that we have to start thinking seriously about interlibrary loans in Ghana. It's one thing we don't do. The University of Ghana has arguably the oldest law library in Ghana. I don't know about the Supreme Court, but I'm talking about the universities. I'm sorry? Well, the oldest law library in Ghana. We'll talk about the others later. But the oldest law library in Ghana. The University of Ghana invariably, therefore, has much more, quote-unquote, antique materials many universities in Ghana don't have. Other law libraries elsewhere may also have some modern materials University of Ghana and others don't have. I think it should be okay for a system to be in place where students of the University of Professional Studies, where I teach, are able to apply for materials from the University of Ghana, and that system should be of such a nature that the University of Ghana should not be worried about its materials coming. Dissertations and theses that are published in our various faculties and universities, what is the database for cross-referencing for faculty members and researchers in this university and others to be able to access materials elsewhere? I think as we discuss these issues, we should also discuss the issues of leveraging. And this business of silos mentality, of everyone praying for the failure of the other, and everyone basically just trying to do as much as it can while hoping that its strength is the weakness of the other. That pays in some things. Indeed, will remain competitive, and we are all looking for students, so that competition will still remain. But there are areas where even the most competitive environments, like America, have been cooperating. And so this business of being in our spaces and corners and trying to fend off everybody else, it is simply unsustainable, and we are all losers in the end.
This is something which has also engaged my thinking for some weeks now. Initially, when we met with them, I told them that as far as I was concerned, they should start in October next year, as the Attorney General had laid down. But at the last council meeting on November 26th, what I told council was that I was thinking of another way out in order not to affect adversely those who are coming in next year. And I also promised the General Legal Council that I would come up with some solutions for their consideration within the month of December. So that is what we are committed to, so that we can prevent that situation which we are worried about, that if there's a block of 500 students already, and space is limited, that would affect the number of students we can add. And I'm sure the pass mark would go up if we do it that way. So we are thinking of an alternative, and that would be provided by, we would provide the General Legal Council with our recommendations, and then if they consider it and they approve it, then I think that is what we are going to do. So for now, I can't say anything beyond that, because I would also have to wait for approval from the General Legal Council. Okay. I hope that answers your question. Plans are far advanced. And then, which is the other question?
I just want to weigh in briefly on this issue of answering questions by law students. Now, it is imperative that you ask yourself, before you answer questions, what exactly is the question you are asked to answer? Many law students don't pay attention to this. You may be given a case problem scenario to answer, and you're asked to advise parties. In some other cases, you are given the same case problem with issues, and you are asked a specific issue to discuss. I remember asking my students in one semester, I've constructed the case problems, and I asked them without discussion, identify all the issues involved in this case. That is A. Because the first one is for them to elicit these issues and test their knowledge, of the law on the facts. Then the second question goes directly to one of those issues for answer. 95% of the class, in fact, discuss all the issues. The question I'm asking, without discussion, identify issues. So if you discuss all the issues, and by the time they finish discussing the issues, because the issues are many, so there wouldn't be time, none of them had time to answer the actual question that they were asked to discuss. So those are issues that often come up, and they write in pages. At the end of the day, most of these students fail that particular question. So you really have to pay attention to language. If you're asked to advise parties, that is different from when you are asked a specific issue for discussion. So if you are not patient with yourself in examinations, and there are so many issues that come up when you are in examination setting that really confuses, any student on a bad day. So those are issues, in fact, that's the advice I will give. Pay attention, understand, and you must be confident that you are giving a one-paragraph answer. That doesn't mean it is a wrong answer. You don't have to write 4 pages for a paragraph or a page. It doesn't make any sense or difference in that situation. Thank you.
All right, thank you very much. Can we have one more round of questions? There was, I think there was a question about attendance, yes.
Well, we have a new campus at UPSA. The class prefect has my number, has a number for the registrar, has a number for the deputy registrar. That's the first step, that if there's any issue, they should get in touch with us. I've not heard any complaints so far about lecturer a lecturer not attending lectures. If it's once, fine. But if it's consistent and you are hearing it over and over from the lecturers, from your colleague students, it's something that we would investigate. Okay, thank you.
Okay, so while we wait for the next round of questions, I have a question for, I think this one goes to Mr. Prempe Ek from one of our online participants, Xavier Komla Subia Dekuma. She says, With regards to student loans, I had my LLB from the University of London. In search of funds for my tuition, I tried the Students' Loan Trusts in Ghana, but I was told they don't support law school fees. Please, I would like to confirm if the students in the Ghana School of Law have access to the Students' Loan Trust scheme.
I believe they do. I believe they do.
Okay, so Xavier, I hope that answers your question. We're still on the International Conference on the Future of Legal Education in Ghana. Today we've been talking on the topic resources on legal education. So please, we are still in the Q&A session. Any more questions from our online participants or participants here with us today? Okay, so while we wait for you to make up your mind, Professor, Dr. Tupari would like to make some few comments.
Because my name was specifically mentioned, I didn't want to be seen as running away from the question on harmonization of values on legal education. In fact, I made that point, but I'm not suggesting that we should try at all costs to harmonize methods of teaching and the methods of assessments. Courses are different. Lecturers will be different in their approach. And then the lecturers will also be different in terms of how they conduct lectures. So we can talk about common values for legal education that we would like our students to have. For instance, critical thinking, the entrepreneurial mindset or problem mindset that Madam Isabella talked about. And what have you. These are things that we might want to say are at the core of our legal education. But we can distinguish methods of teaching from methods of assessment. How do you teach in the classroom? That we shouldn't force it on any person and say that we should have some common methods of teaching, because the subjects are different in terms of content, orientation, and what have you. How do you assess the student might also be different. However, I agree with you that feedback is important. Feedback is important. How sufficient is the feedback? How are lecturers able to tell you your problems when you provide answers? It's just that within the current context, with the level and numbers of students that we have, speedy feedback might be difficult. For instance, I have given you a problem question for 300 students. I'm supposed to mark that within 2 weeks and get back to you. I think yesterday you said we should speak the truth. And the truth is that I am not going to be able to deal with these 300 scripts within 2 weeks and get back to you to be able to tell you one by one what I think is the problem. I might give you general comments. For instance, bad grammar, on your inability to appreciate principles. Probably you don't pay attention to details, due diligence, and all kinds of things. I can provide that kind of feedback. But see, evaluations are important. Yesterday, they made mention about evaluation. I don't want this point to look like it's just a one-track issue. We want to give feedback to students, and we, the lecturers, don't want to get the feedback from students. So when you evaluate us, we expect to get candid views from you. If you make wild statements like, he's fantastic, she's fantastic, what's that supposed to mean? What does that tell me? Or he's a boring staff. What's that supposed, how does that guide me? We will require some kind of specific articulations that will help us to know the way forward, how we should restructure ourselves, how we reorganize ourselves, and what if you has colleagues, we should be able to speak frankly. I have always been talking about frank communication. When I was a student, Leadership Justice Professor Nelson Bonsu was my criminal law lecturer. She has never on any occasion seized the opportunity to tell us how we can discover our talents by reading and applying, the readings that we have done in the classroom. She needs not tell you the ratio, but the environment provided in the classroom will let you understand that this is the ratio of the case. But there were some, anyway, I'm not going to mention names, who will tell you the ratio of the case. They would never tell you the ratio of the case, only for you to write and to say, that is not the ratio of the case. We are not expecting them to actually give us the ratio of the case, because you never know the ratio of the case in that case until you leave this faculty. And that is something that we should be able to tell ourselves, frankly, that your 60-day students are not our 300-day students now. So maybe there will be difference. Thank you.
All right. Thank you very much. I think you agree with me that it's been an interesting afternoon, and we are slowly getting to the end of our proceedings for the day. I think our chairman has been very fantastic. He's been a good, captain of our ship. And let me say, he has some equally important engagement, elsewhere, and has asked, permission to leave. So is also Professor Icflea here. Also has another important engagement elsewhere. As you can imagine, getting to this time of the year, they have a lot of invitations that they have to deal with. So they've asked for permission to leave us so that we can continue with the proceedings. Thank you very much. Mr. Chairman, we are very grateful for your leadership this afternoon. And Prof, it's always a pleasure to have you here. You are officially the proper landlady, here. And we are happy that you graced, this our occasion. We wish you all the best as you leave us to be with those others that are waiting for you as well. Thank you very much. All right. So we'll do one last round of questions, and then we'll take some remarks from our panelists, and then we'll start winding down, bringing the proceedings to an end. So I see a hand up there. Any other? Can we have 3? All right, good. So 2. Can we have the last one here? The ladies. We have not had any, lady ask a question or, give some comments. So the ladies, and at least I can see a lot of our students in here. And then the ladies, oh, you have your hand up? Madam at the back, do you have your hand up? Okay, very well. All right, we have 2 questions.
Hello, and thank you very much for this opportunity. I just want to quickly say that you look at other parts of the world and you don't necessarily get the impression that lawyering or soliciting is limited to the elites. But then you look at this country, Ghana, and sometimes it looks as though it is something that is restricted to only the upper echelons of society. And you look at the entire legal educational journey that people have to go through, and you wonder on some of the opportunities that are open to the people at the lower ends of the spectrum. I just want to know if we know in theory it is possible to modify the structure with the School of Law and make it such that people can have the education going through the universities, and then we follow that ICAG model and then they take the exam. As Mrs. Isabel said, that we know that if we change things, there are certain things will be lost. If we know in theory this would widen up this profession to allow more people in, I would like to know what is really standing in the way of making these changes, because it's more forward thinking and not looking into the past. So I'd just like to know what exactly is holding us back. Thank you.
Yeah, thank you for the opportunity. I want to talk about the use of books in the library by faculty spread around. And I will say that it's good that you have a material that people will come and use. I think the value of the material is the number of times that students or users use the material. So if by the grace of God you have a material that people are bent on using, then it's a good thing. But I also believe that it is the aggregate of the number of times that people use the material that shows the deteriorating nature of the material. So I would suggest that the heads of faculties can come together as a consortium and use materials in the library accordingly. And I believe that when there is a consensus or there is helping hands, we will be able to manage that very well. So my suggestion is that heads of libraries should come together and see the way forward, how materials can be acquired so that it can be used for the very good of students in Ghana. Thank you.
All right, thank you very much. So I will, since it's a question on libraries, I will let Uchi, go ahead and give some comments about that.
Well, I don't think I have an answer. I think it's a comment and a useful suggestion. I indicated that there are concerns, and I recognize you. That's Abraham, right? And the librarian. Yeah, so I recognize you. I know that there are concerns. Materials in library are almost of a security nature, and it takes a lot of money and effort to gather them. So I recognize the fact that allowing students from other universities over whom you have very little superintendence or control is one that is unsettling. I recognize that. However, we don't cry over problems. What we do is to solve them. So what I'm saying is that we need to leverage over the opportunities presented by the diversity of materials. The University of Ghana, arguably, as I said, you must be a leader in, as far as the library is concerned. That's easy. Now, other libraries are much younger, but they also have materials that you may not have here, which may be comparatively newer. And the same goes for all the other faculties. So we can all leverage on these things by giving our students broader access to materials if we create a general database of access. The most important thing is, how do we ensure the security and the preservation of use? And other jurisdictions have done it. We don't have to reinvent the wheel. We probably just have to understudy them and find out how they've done it. And to deal with these areas of concern, use, return, it being in the same shape in which you took it, the issue of preservation, and making sure that ultimately we can leverage on this without undermining the sustainability of these materials and the questions of security. So that's the point. I recognize the difficulty, but I don't think we should sit back and just complain about the worries.
All right, thank you very much. I'll give the last word to Professor Ige to tell us his experience in Nigeria with respect to the use of library resources.
Thank you. I think my colleague here actually answered the question. And it's not just in Nigeria, it's everywhere. There is interlibrary loans, that is being practiced. If there's a particular resource that you need, you consult your librarian, they will arrange the book for you from another library. What is imperative is that you keep the book in the form in which you receive it so that others, after you can also use it. So, and it's also very important that you do not lose library books. They are valuable, they are protected, and they are jealously guarded. So there's some element of responsibility on the borrower's part, because that is the only way through which that particular stream can continue to flow. Once there are breaches along the way, then you discourage interlibrary loans, because every institution will want to protect its own acquisition. And as a result, they really hope that when books are borrowed, they will be returned. And it is done even abroad. At Osgood, because I studied at Osgood at some point. So if you do not have books in our library, you go to U of T through the librarian, and the books come to where you read, it's placed on your table, and the dates are there when you should return these books. You return it to the same person that borrowed it for you, and it's also returned to U of T. So that is how these things are done. Thank you.
All right. Yeah, Mr.
Thank you very much. Masanda,
we
are running out of time, I beg you. Masanda,
resource.
We are running out of time, I beg you. I think you will agree with me when I say that we saved the very best for the last. It's been quite an interesting afternoon. We thank our panelists very much for their contributions. We thank you also very much for your participation as well. Those of our colleagues that are joining us online, we thank you as well. At the right time, someone will come here with a sweet voice and come and give you the proper, thank you. But at this juncture, we are going to move to a different, segment of the program. We are going to go ahead and have our our closing remarks. That is going to be given by Her Ladyship, Professor Justice Mensah Bonsu. Once again, she needs no introduction. For me, she was my teacher. She taught me not only law, but she taught me life as well, and then also gave me a wife in addition to that. So she's very, very special. So we invite, with a round of applause, if you can invite Professor Justice Mensah Bonsu to the podium. Thank you very much.
Distinguished members of the podium, distinguished participants, deans, members of staff, and all who are here, who are duly recognized. I prepared a speech in order not to digress. When you give a professor a microphone and an audience, you are taking a risk. And in order not to heighten the risk, I've prepared a speech. So permit me to read the speech that I've been working on all day. The Dean, is he here? Let me begin by thanking the Dean and other organizers of this conference for turning to me during injury time to execute this assignment. While muttering about the inconvenience of such a last-minute request precisely last night, I cannot help but observe that it not only bespeaks the great confidence they must have in my ability to deliver at short notice, but also the subliminal message it conveys that when you are in trouble, see Mensabi and she will come through for you. I therefore accept the honor of this assignment with good grace and deep humility. Legal education is about more than a discipline. It represents the hopes, aspirations, nay, faiths and destinies of many young people, families, communities, the state, and society at large. Therefore, to be tasked with the responsibility of driving it into the future when it must retain its function, meaning, and relevance is no mean task. This is what all of us, led by the deans, have gathered here to think through these past 4 days. Once upon a time, I became a law student, little knowing that it was from a state one could never withdraw. And so I have remained a student of law ever since. For the enterprise of law is a continuing one, never letting up, never relenting. As a former law student, I know the endless slog at studies that studying law entailed, as well as the endless trips to the law library that was demanded of me. Acquiring a mastery of particular aspects of law, as our teachers emphasized time and again at our weekly tutorials, or small groups, as some prefer to call them, meant applying ourselves to our studies in a manner that surprised our peers in the social sciences. When I gained admission into this university to read law, my parents were excited at the new possibilities for me and the hopes and aspirations that that event ignited in their breasts. As a parent, I have myself experienced those emotions twice over, and so I know the hopes, elation, and raised expectations when a child achieves the enviable title of law student. I'm sure you agree. The instantaneous respect that is accorded a person introduced as a law student by peers is not only an ego booster, but well earned, for it must serve as a reminder to him or her that having made a choice to enter the legal profession, the person has assumed a burden of serving the world through representation of the voiceless and reshaping the world for the future. As a law teacher for much of my life, I have known the highs and lows of trying to work on a young, brilliant, and eager mind, to lead it to explore existing ideas, open it up to its own potential to create and recreate ideas, even unpopular ideas. I have known the thrill of hearing a once shy and diffident young person articulate with confidence and conviction a position that more eloquent peers may have spurred. There certainly must be few occasions that rival such days in the life of a law teacher. I have also experienced the look of trepidation followed by pleasure that always greeted my assurance at tutorials that the students in the class represented the brightest and best of their generation. It also served to convey not only the fact that their endeavors would represent the heights of human achievement in their generation, but that the gift of high intellectual capacity imposed upon them a commitment to learn hard to be the best that they could be. The unstated message was, if I may quote the motto of Legon Hall, to whom much is given, much is expected. As an academic, I have also known the stress of trying to build a career alongside all other social aspirations human beings crave, in a profession which is jealous of its own and which is constantly changing its assumptions as the circumstances of human beings change. This, unlike other professions, constantly reminds a teacher that one will never be free of the people one teaches, and that the results of one's work and one's reputation will be constantly on display before one's very eyes, either in the corridors of power or in the halls of justice. The question every law teacher must ask of himself or herself is, will I be able to hold up my head during such encounters, or feel compelled to proffer mumbled apologies for not having been what I should have been to this former student at the time that was and in the circumstances that were? When I became the Deputy Special Representative for the Rule of Law in the United Nations Mission in Liberia, UNMIL, I had responsibility for leading the UN's efforts at post-war reconstruction of the legal sector. I began to appreciate how important it was for a leader to be respected for disciplined competence in the specialized sector. I also appreciated how enduring habits of industry ingrained in the practice of all aspects of the profession are when deployed in other areas of life. The special nature of the discipline became much clearer to me when I found that to rebuild a legal sector, one had to consider not only those already administering the law in its various aspects, but also those being recruited to join their ranks to take the profession into the future. The content of the training had to be of interest and responsive to the needs of society, both in the present and in the future. One had to ensure access to the widest range of citizens by securing appropriate funding to support the vulnerable. For every rung of society deserves its own, so that its needs and interests could be properly articulated. The need to provide assistance and support for the chief civil society instrument, the Bar Association, also became an imperative because the Association of Lawyers, howsoever called, represents a nerve center for ensuring not just the adherence to ethical standards by lawyers, but also the capacity to provide opportunities for continuous legal education. These became imperatives because, as far as I know, law is the only sector where all functions are interlinked and where anybody trying to improve the law must look at law students and what they study. Thus, producing the law, determining the law, applying the law to adjust rights and obligations of citizens, enforcing the law to maintain societal order and development, predicting the predilection of the law in foreseen as well as unforeseen circumstances, enforcing ethical standards within the profession, extending the boundaries of law, cultivating a culture of respect for law and human rights to shore up the functioning of the institutions of law, improving access to law by citizens to assuage yearnings for justice. In short, law and its adherents, practitioners, and advocates must achieve all of these functions if law is to become and or remain a pillar on which society may lean for its good order and orderly development. The consequences of not living up to the bill in moments of difficulty is that self-help, and for self-help, read war, acquires the aspect of being the only viable option, of course, with devastating consequences. Therefore, a restoration of rule of law in which the legal profession plays no mean part is literally the best indicator of the restoration of civil order and a marker of the health of the society. This makes the state and society at large a major stakeholder in the quality of its legal profession and the training of its future assets. Now I am on the bench and having to live the critiques I spent my life putting forward, I have a better appreciation of the value that my legal education has served in my development. As one whose stock in trade is serving up justice in the highest court of the land, I am particularly conscious of the extent of trust reposed in me by society at large and affected persons in particular. I speak of these things because that is what these past 4 days have been about. giving value to our stakeholders, students, families, professional colleagues, the ordinary person, in days of yore called the reasonable man, the state, and the global community. It is also about the output and eventual product of what all law faculties are about and or have been set up to achieve. Quality human resource, well trained in the law for the ordering of the society of the future. Into this mix of varied stakeholders with their varied expectations has been thrown technology, which has changed our modes of communication and research. Each of these stakeholder communities has its own peculiar interests that impose certain imperatives on schools dedicated to the study of law. These past 4 days, you have joined minds and hearts to look at what you have been doing, to ascertain whether what you have been doing is fit for purpose, and whether you should change tack and redirect your efforts, or continue to do what you have always done, with the necessary modifications as circumstances dictate. These are the issues, whether articulated or not, that have taken your attention. The in-depth discussions on topical issues confronting legal education in Ghana and Africa have been a blessing, for we have been alerted to the conditions that we either have to take control of or be controlled by in the ever-changing social terrain. A public health emergency has descended upon us without warning and challenged all the paradigms of rights and responsibilities, as well as the use of the state's police powers and the protection of the state's economic interests and general well-being. What is required of the discipline of law in times like these? And how may we be positioned to take the best benefits from circumstances over which we have no control? Deep thought and philosophical inquiry is required. However, competence in the functioning of existing law and doctrines of law cannot be overlooked or underplayed as we soar into speculative realms and deal with possibilities that fertile minds can conjure, but which may have no immediate practical application. The average person looks to the law for the here and now solutions to issues confronting them. But unless the boundaries of law are continuously examined, explored, and tested, new and emerging situations would overwhelm the system. How to achieve this balance must therefore engage the attention of those whose task it is to develop minds of the next generation. In doing all of this, sight must not be lost of the fact that in a globalized world, we need to take account of developments that put us in competition with people trained elsewhere. Many Ghanaians serve in international organizations or in other jurisdictions. Ghanaian trained judges and lawyers, including my own sister, who was Chief Justice of the Gambia and is now Chief Justice in the British dependency of Turks and Caicos Islands in the Caribbean, have long been a resource for the Commonwealth Office. This reality imposes a duty on us to constantly improve the quality of the legal education we offer, for the competition is now global and the market is an unforgiving terrain. We cannot also overlook the quality of students we recruit, because the effort to cultivate an inquiring mind can be made even more arduous than it is already if there is very little by way of a mind at the other end of the pole. As a Ghanaian proverb goes, however good cassava tastes, it can never pass itself off as yam, for the telltale string in the middle will always give it away. Recruitment based upon careful selection and by merit rather than family connections or political decisions will yield good returns for the enterprise of quality legal education. In these 4 days of exciting discourse, the broad themes covered have spanned the following: policy, legal management, ethical frameworks of legal education, comprising sub-themes, policy framework, legal framework, management and administrative framework, and ethical framework. Curriculum development and teaching methodologies, comprising such themes: curriculum, teaching methodologies, quality control, and examination and testing. And resources for legal education, comprising the sub-themes of human resource, institutional resource, infrastructural resources, and financial resources. I believe we have just come out of that session. After action is always a critical factor in achieving impact. Having spent such valuable time expounding on issues of relevance, it is the hope that the detailed conference report would be made available for the consideration of all faculty, bench, and bar in the countries here represented. Fortuitously, the Attorney General of Ghana is working on a legal profession bill. So hopefully this conference report would be a resource for generating provisions to meet the expressed aspirations of lawyers, both current and future. Certainly not the aspiration to make an A when you have presented a D essay. The international participants, Honorable Justice Dr. Abu B.M. Bine Kamara, Justice of Sierra Leone's Supreme Court of Judicature and Dean, Faculty of Law, Furabe College, University of Sierra Leone. Professor Anthony Diala, Director, Center for Legal Integration in Africa. Professor Olaolu Upadere, Dean of the Faculty of Law, University of the Gambia. Professor Ige Bolodioku, Dean of the Faculty of Law, University of Lagos, Nigeria, have all added some spice to their discussions and moved them from parochial streams into international waters. In the end, their participation has justified the belief that the human condition is the same, and the issues confronting legal education in the common law world are all the same. This conference marks our effort to swim together to navigate the shark-infested waters more efficiently. I am informed that discussions have been initiated for the setting up of an Inter-African Law Deans Administrative Law Network to ensure an integrative approach to resolving the issues surrounding legal education in Africa. The effort should not end here today. I call on all law faculties to organize follow-up seminars and other interactive sessions to increase the sense of ownership that these recommendations represent. Everyone has problems, but only those who are so minded can effect the necessary changes to achieve desired reform. The buy-in of all important players in the sector has become imperative if success through joined-up effort is to be achieved. All the reforms we wish to see require funding from all stakeholders to implement. It is for this reason that we are grateful to His Excellency the President Nana Addo Dankwa Akufo-Addo for setting the sterling example of making a personal pledge to donate 100,000 cedis to the endowment fund. In this fundraising effort, judges, lawyers, alumni, and the private commercial sector are all encouraged to make their presence felt. It must always be remembered that the quality of those who handle their legal affairs may save them money or impose needless expense on them. As was said on Monday, a badly trained lawyer is a danger to himself or herself first, and then to the society next. Therefore, helping to fund quality legal education is in their own best interest. I cannot end this speech without specially acknowledging, on behalf of the Dean, the support of the leaders of all three branches of the government of Ghana. His Excellency the President of Ghana, Nana Addo Dankwa Akufo-Addo, the Speaker of Parliament, Right Honorable Speaker Alban Bagbin, represented by the First Deputy Speaker, Honorable Joe Osei Owusu, MP for Bekwai, and His Lordship, the Chief Justice, Mr. Justice Kwesi Ani-Yeboah, also represented by Mr. Justice Jones Doche, the most senior justice of the Supreme Court. The Honorable Attorney General and Minister of Justice, Honorable Godfred Yeboah-Dame, Ministers and Deputy Ministers, His Excellency the German Ambassador and GIZ, last but not the least, the Vice Chancellor of the University of Ghana, Professor Nana Aba Appiah-Amfu. All of these distinguished personalities lent gravitas and fillip to the opening ceremony. The publicity that was engendered in the media by their presence was immeasurable due to the purpose and purport of the conference. Not to cast in the shade the contribution of the institutional players, I acknowledge with gratitude the contribution of the law deans, roundtable chairpersons, speakers, panelists, moderators, and conference participants who have all ensured a very successful conference. To the conference organizers, we who participated cannot thank you enough for the dedication which made a 4-day event pass without incident. To the Dean of University of Ghana School of Law in particular, who not only dreamt of such a conference at this time, but put muscle and will behind it to make it a reality, go our heartiest congratulations. All other categories of staff who worked hard for weeks to make the arrangements for these 4 days seem effortless, go our appreciation. It is said that the strength of a chain is in its weakest link. And so the success of this conference is traceable to the contribution of its least and lowest. The speeches have now ended. Now begins the work, the very hard work. May God bless our efforts. I thank you.
All right. Thank you very much, Your Ladyship, Professor Justice Mensah Bonsu. After that speech, you don't have to say anything. Yes. So may I, at this time, invite the representative of LSU to give us the vote of thanks. As a rep from the Law Student Union of University of Ghana to give the vote of thanks.
My name is Ransford Kwame Baini, Vice President of the Law Students Union. Honorable Chair, Mr. Kwekwan Sasari, respected speakers, Dr. Peter Tupari, Mr. Kwesi Prempe Ek, and respected panelists, Ms. Isabel, Prof. Abuchi, Prof. Ikea, Prof. Ige from Lagos, Nigeria, and our most valued moderators, lecturers present, invited guests, distinguished ladies and gentlemen, fellow students. And fine weather for all the days of the conference. I, on behalf of the Dean, Prof. Raymond Atuguba, and the entire hearty vote of thanks to our speakers for gracing this occasion and sharing with us your opinions and findings. I must mention our deep sense of appreciation to the German cooperation under the implementation of the GIZ for their cooperation and sponsorship in the organization of this conference. Well, Mr. Chairman, the organization of an event like this cannot happen overnight and requires proper and effective planning. Preparations towards this conference commenced about weeks ago. We have been fortunate enough to have been backed by a team led by Dr. Sena Deititu and very motivated and dedicated colleagues, students, and staff of this school who know their job and are result-oriented. Further, we are very grateful to her leadership, Professor H.J.A.N. Mensah Bonsu, for gracing our closing ceremony with this massive speech. I cannot thank everyone for their involvement and their willingness to take on the completion of tasks and even beyond your comfort limits or your comfort zones. Mr. Chairman, once again, I want to state that we are all most grateful to all speakers who have been on this stage for all the days of this conference. It's been a great pleasure. And as we bring this conference to a close, we hope and we pray that the intents and purposes for the organizers of this conference will come to fruition, and that whatever thing the organizers foresee would come to fruition. Thank you all so much for participating. It's been a great pleasure. Thank you.
All right, thank you very much. So with that, we have come to the end of our conference. I will entreat all of us to remain seated as the dignitaries at the high table make their exits. And then it will be followed by our special guests that are sitting in the first two rows, and then all of us will follow suit. Thank you.
The rule of law and a transparent justice system lay the foundations for inclusive and fair development. In many African countries, there is a need for action to to ensure compliance with the principles of the rule of law and justice. The project focuses on the promotion of the rule of law and judiciary and the improvement of the legal frameworks for entrepreneurs in Africa. In addition, the cooperation with bar associations and universities across Africa have built important cornerstones. The team in Ghana has worked on a long list of activities in the past years, from training of lawyers, establishing a network between bar associations, workshops to empower female entrepreneurs, and enhancing women's access to justice, to conducting research and studies, organizing summer schools, workshops for women judges in Africa, and analyses and baseline studies, and many more. An online conference was organized to exchange ideas between Germany and Ghanaian judges and court administrators on methods for implementing digitalization in the justice system, and to share the lessons learned in Germany and Ghana.
We don't usually get the opportunity to actually benefit from shared experiences of other jurisdictions so that we can inform what steps we are going to take. We don't want to reinvent the wheel. We want to take the benefit of what others have done and then customize it if necessary to our own situation, improve upon it for the use of our system.
In partnership with the Fair Justice Initiative, the project trained detainees of the Insawam female prison in creating face masks and hand sanitizers and distributed those to the local communities.
As part of our core missions, we provide skills training, educational training as well to inmates. So we tied this in with the COVID awareness program. And what we hope to achieve with this project really is to train these inmates for them to acquire some skills that they would rely on when they are out and when they are released. This is supposed to give them some economic independence when they are out there to support themselves.
In cooperation with the Office of the Attorney General and Ministry of Justice, the project developed a web application to be a one-stop shop for case law in Ghana that provides a digitized collection of Ghana's previous and current legal decisions to encourage the complete transition into e-research, making it an indispensable part of the African legal profession. In Tunisia, Ghana, Cote d'Ivoire, and Mozambique, the team focused on supporting knowledge strengthening and exchange for lawyers and entrepreneurs, small business holders, founders, and startups through summer schools. Legal coaches from all over Africa support students with their participation at international legal competitions.
The pleading is over. I felt confident. They didn't ask many questions, but I was able to finish all my arguments.
The project also produced a podcast that shared general knowledge on legal background information.
Most African advocates will be guided and be motivated so that they will go all out to give their all for the vulnerable, the poor in society, and bring justice to every manner of person who may need this justice, and without them, they will languish in jail.
Several workshops and activities that strengthen women lawyers have taken place in Cote d'Ivoire. The team also supported the availability of legal aid in communities on access to resources, land conflicts, and women rights. With a specially designed truck, the team, with the support of the Ivorian legal practitioners, have visited communities giving free legal advice on request.
L'association des femmes juristes a pour mission de divulguer, d'informer et de sensibiliser les populations sur les questions d'ordre juridique et judiciaire. Et dans ce cadre-là, elles ont créé les cliniques juridiques qui sont des centres d'écoute, d'orientation près des populations. Donc, elles sont proches des populations, elles orientent les populations à aller dans ce sens. Et dans ce cadre-là, ça oblige aussi les gens à parler. Parce que ces problèmes de violence basée sur le genre, de viol et autres, là, sont des problèmes, personne n'en parle.
Cette activité, c'est très très important dans notre vie, puisque ça a changé beaucoup de choses, surtout le viol. Avant, quand on partait au champ comme ça, là, on a peur. Mais depuis cette activité est venue, là, on ne nous agresse plus.
Ici à Zokogwe, nous avions beaucoup changé. Dans le passé, les gens frappaient leurs femmes. Mais depuis que le cabinet juridique à Zokogwe, nous connaissons tous la loi. Tout le monde marche sous la loi. Et ça nous a appris beaucoup de choses. Travailler avec nos enfants, avec nos femmes surtout. Aujourd'hui, on peut même aider une femme à son absence, on peut aider une femme à préparer. Nous respectons la loi.